taking that burden. We'll be doing all the initial reading, so I can drop it straight from 4 to 2 days.
So we'll take a realistic call and give a amended
side,
schedule.
If you all sit together and take a realistic call, I think we'll be able to get a revised statement by tomorrow, I think.
One item, that is item number 24 in 901, that is Dalmia Cements. There were two sets of matters, one from Tamil Nadu and the other from Kerala. Both were heard together. But only the Tamil Nadu matter has been posted, whereas the Kerala matter is left out, my lord. So I can give the number.
There is a slight nuance there. But we are the patadas, owners of the land.
Yes.
Under the Tamil Nadu Act, 50%, if you're the owner, the tax was 50. Then it became 100.
Right.
Then the question is whether Theresa Ma Jacob applies, whether the land mineral belongs to me or not. Those issues are peculiar to patadar lands and Janmi lands.
Yes.
You may not take it up just now. I think all the 11 questions can be considered.
Exactly. We'll look at the questions which have been formulated. It's a reference.
And matters will go to the regular.
So what we'll do is, whoever wants to argue, if Kerala, the matter is not here. We are not going to look at the individual acts really.
From Tamil Nadu, Dalmia and Cements of Tamil Nadu.
No,
But my humble
So
submission
we'll
is,
hear you on this side at the end.
Basically, the question is as to whether.
Your lordships, look at the question. Give it to individual basis.
Absolutely.
yeah.
Because if you go act by act, question by
It will
question,
never be resolved. Then it will.
I shudder to think how long this will take.
And not what there are separate land laws in every state from the British days, land settlements.
And then that individual bench will, in the light of the answer to the reference, look at the acts in question.
Only thing is that, my lord, the same
We
question.
made it clear. I think. Let Mr. Vedi open. Yes.
Please, my lord.
Yes.
But there are various petitions which are arising from Odisha, Jharkhand, and other states. Out of these, Lord, the laws made by state of Odisha and state of Jharkhand were struck down by the High Court. I am appearing in the matter, my lord, of state of Jharkhand, which is Civil Appeal 4056. (4056-4064) of 1999. Mineral Area Development Authority versus Messrs. Steel Authority of India Limited. And so far as state of Andhra Pradesh is concerned, Lord, it is against an interim order granted by the High Court. And Chhattisgarh, Madhya Pradesh, Rajasthan, Tamil Nadu, and UP, the laws were upheld on the basis of the judgment of this court in Kesharam. So therefore, there are 5 appeals, Lord, and therefore, in a sense, Lord, both sides are appellants. But the reference was made in the state of Jharkhand's case, that is MADA, Lord. In short, MADA, MADA. If I may place, Lord, the reference order. Achha, page 9, PDF number. May I place the referring order? Having heard the matters for considerable length of time, we are of the view that the matter needs to be considered by a bench of 9 judges. The questions of law to be decided by the larger bench are as follows. 1. Whether royalty determined under Section 9, read with 15, subsection 3 of the Mines and Minerals Development and Regulation Act 1957 is in the nature of tax. Can the state legislature, while levying a tax on land under List 2, Entry 49 of the 7th Schedule of the Constitution, adopt a measure of tax based on the value of produce of land? If yes, then would the constitutional position be any different insofar as the tax on land is imposed on mining land on account of List 2, Entry 50 and its interrelationship with List 1, Entry 54? 3. What is the meaning of the expression tax on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development within the meaning of Schedule 7, List 2, Entry 50 of the Constitution of India? Does the Mines and Minerals Development and Regulation Act 1957 contain any provision which operates as a limitation on the field of legislation prescribed in List 2, Entry 50 of the 7th Schedule of the Constitution? In particular, whether Section 9 of the aforementioned Act denudes or limits the scope of List 2, Entry 50. 4. What is the true nature of royalty dead rent payable on minerals produced, mined, extracted from mines? This 4 is actually subsumed in 1. 5. Whether the majority decision in state of West Bengal versus Keshoram would be read as departing from the law laid down in 7 judges bench decision in India Cement Limited versus state of Tamil Nadu. 6. Whether taxes on lands and buildings in List 2, Entry 49 of the 7th Schedule to the Constitution contemplates a tax levied directly on the land as a unit having definite relationship with land. So there's really no problem about 6, the correct answer given by the question itself. The only issue will be, what do we understand from this? 7. What is the scope of the expression taxes on mineral rights in List 2, Entry 50 of the 7th Schedule to the Constitution? 8. Whether the expression subject to any limitation imposed by Parliament by law relating to mineral development in List 2, Entry 50 refers to the subject matter in List 1, Entry 54 of the 7th Schedule to the Constitution. Whether List 2, Entry 50 read with List 1, Entry 54 of the 7th Schedule to the Constitution constitute an exception to the general scheme of entries relating to taxation being distinct from other entries in all the 3 lists of the 7th Schedule, as enunciated in MPV Sundara Ramayya and Company versus State of Andhra Pradesh. 10. Whether in view of the declaration under Section 2 of the Mines and Minerals Development Act 1957, made in terms of List 1, Entry 54 of the 7th Schedule to the Constitution and the provisions of the said Act, the state legislature is denuded of its power under List 2, Entry 23 and or List 2, Entry 50. What is the effect of the expression subject to any limitations imposed by Parliament by law relating to mineral development on the taxing power of the state legislature in List 2, Entry 50, particularly in view of the uniqueness in the sense that it is the only entry in all the entries in the 3 lists where the taxing power of the state legislature has been subjected to any limitations imposed by Parliament by law relating to mineral development. Before concluding, we clarify that normally the bench does about the number of benches. Although 11 questions have been framed, but in my respectful submission, there are only 5 questions which are arising. The first and the most important question is, what is the true nature of royalty determined under section 9-7?
Determined under section 9.
Read with section 15 bracket 1 of the MMDR Act, if I may use this
Yes.
acronym, 1957, and whether royalty is in the nature of tax. That's the first question. Now, issue number 1 and 4 will be subsumed in this. The second question will be, what is the scope of entry 50 list 2 of 7th schedule of the Constitution of India?
What is the scope of entry?
What is the scope of entry 50 list 2 of 7th schedule of Constitution of India?
Yes.
And connected will be, what is the ambit of within court limitations imposable by Parliament? In exercise of its legislative power under entry 54 list 1. Look, I will not be referring to a 7th schedule of the Constitution every time. Only entry I'll put for convenience.
Yes.
Does section 9 or any other provision
This is the third item.
in the same section? In continuation,
Yes.
does section 9 or any other provision of MMDR Act contain any limitation with respect to the field in entry 50 list 2? The third is, so this is all about entry 50. Third, whether the expression subject to any limitations imposed by Parliament by law relating to mineral development is subject to, till development can be put in quotes, subject to any limitations imposed by Parliament by law relating to mineral development. In entry 50 list 2, pro tanto subjects the entry, pro tanto subjects the said entry to entry 54 list 1, which is a non-taxing general entry. And consequently, there is any departure from the general scheme of distribution of legislative power as enunciated in MPV Sundara Ramayar's case, that is 1958 SCR 1422. 1958 SCR 1422.
Just one second.
May I repeat this?
Yes. What is the citation of, can you repeat this?
1958.
Consequently, is there a departure from the
General scheme of distribution of legislative power
as stated in MPV Sundaramaiah?
as 1958 SCR 1422. The fourth question is, what is the scope what is the scope of entry 49 list 2? And whether it envisages a tax which involves a measure based on the value of produce of land.
Measure on the value of the produce.
Of land. In continuation, would the constitutional position be any different where mining land on account of entry 50 list 2 read with entry 54 list 1? The fifth question, my lord, is whether entry 50 list 2 is a specific entry in relation to entry 49 list 2. And would consequently abstract mining land from the scope of entry 49 list 2. Abstract lordship may say or oblique or exclude.
Yes.
Yes. And the sixth question is whether that, of course, there is a conflict, Lord. So this question, Lord, whether there is a conflict between India Cement, the conflict is there, Lord. Incidentally, a question could have arisen, Lord, whether 5 judges could have held that certain observation.
According to you, Kesaram is in conflict with
That's right.
Testament, but that's not something they accept as such. Doesn't really. We are on a bench of
That's what
9,
I'm saying.
so we are looking at
Lordships
the
are
entirety of the
considering-
matter at first impression, but
Yes. Or in-
so the sixth question, do we formulate it or no? Not necessarily. Right, because we are a bench of 9 anyway.
Reconcile the two.
That as your lordships have been pleased to observe, while that may, your lordships made an observation with regard to the fifth question, whether that will arise at all or not. It is true, that since 9 of your lordships are deciding the issue afresh, there would still be, my lord, an aspect which this bench may like to say, for the purpose of, my lord, a discipline which the court normally follows.
That's the
What
law
was the
that laid down
option
in Dawoodi Bohra recently, so I don't think we need to really look at that. Be more academic than it.
No, it's
Maybe in
very,
some other case.
Be in some other case. Now it's too important for us to say that the reference is not correctly
I
made.
thought, my lord, that there is arisen squarely here. Lordships may act as well.
Let me just take a minute or 2 minutes on how.
So the sixth point, do we formulate it or just leave it?
I think this is any other issue they want, Lord, I think this
The editors of that.
That is the heart of the matter.
say yes or your lordship.
We
say no.
confine
Does
to
it really matter what India Cement said or what?
What-
9 of your lordship.
what Mr. Dwivedi said at the beginning, that there were 5 questions, we'll keep it down to 5.
Absolutely.
Local government dealt with by the Keshwar Ram, saying that the act under which we are challenged comes with the entry.
But when your turn comes, you can just, we will see what.
Not speaking for ourselves, my lord, I've discussed and what I've
So
seen.
entry 5 may have some incident.
For us in the Constitution bench. There's a live transcript of the proceedings which are being argued here. So at the end of the day, all of you, particularly the lawyers who are in session at that point, get the transcript. Any corrections can be indicated to our IT team. But before we upload it, we have your certification on what has been. We have a complete transcript at the end of the proceeding of, in fact, by the day we have a transcript of the proceeding.
To other entry.
And we are very grateful, my lord, for constituting this 9 judges bench coming up after 20 years, my lord. So whereas the state is suffering from the loss of tax, the other side will be burdened with heavy taxation, my lord. So that will be another issue, my lord. In case the states win, then how to balance, my lord, this? Maybe running into thousands of crores, my lord.
Yes.
So we are very grateful, my lord, for this. The conflict, my lord, if I may just state in a minute, my lord, how this issue had arisen, because
One thing which we may be able to do based on the transcript in the evening. I've got a list of 7, my friend says 5. We've taken down everything he said. The evening, we can just go over between ourselves. Give your lordship a paper saying.
Absolutely.
These are
These are the
Common
agreed
questions, my lord.
agreed questions. Agreed questions.
Reducing, my lord, the number,
Reducing the number as much as
number
possible.
as much as.
in India Cement, my lord, there was this cess on royalty posed by the state. So the issue was never that royalty is a tax. Validity of cess which was imposed on royalty was an issue. And perhaps that case could have been disposed of, as Mr. Sirwai has said in his book, that royalty is an income, my lord, which the state derives from as a part of the sale profits which the lessee gets from the sale of minerals. It would have been invalid on that ground, but then the court went on, my lord, and at one place in para 34, it said royalty is tax in the first sentence. Instead of cess on royalty is a tax. Because the issue was, what is this cess? There was no issue at all whether royalty is tax or not. Issue was only cess, and there was no argument also. But yet in the first sentence of para 34, though it noted that 4 high courts have held royalty is not tax and 1 Mysore high court has held that royalty is tax, but it doesn't dwell on that, doesn't consider, my lord, which is right, which is wrong, no observations. Para first sentence, it says royalty is tax. In the last sentence, it says that royalty is a return for the use of. So there was a contradiction. So when we were arguing, my lord, before the 5 judges bench in Kesharam, and in fact, in 2 earlier occasions before 2 or 3 judges bench, this issue arose that there is no discussion in this and erroneous and this is contradictory and seems to be a mistake. First bench, my lord, in Odisha Cement bypassed it, didn't answer. In the second bench, my lord, in Mahalakshmi Fabrics, they said no, there is enough material to show that royalty is tax in that judgment. So in Kesharam's case, they discussed the whole concept of royalty, which was also not discussed in India Cement. So having discussed the entire concept and all the judgments, including of high courts, that royalty, what is the nature of royalty? And then they concluded that it's a return and it's not a tax. In the process, they went into this question how to deal with para 34. They said that they summoned the original file and original judgment, which was earlier also summoned in the earlier cases. So this was a very live question bothering the court continuously. So they said that the word cess on is missing in the first sentence. If that word is inserted, then it becomes a consistent judgment. or whether 5 judges should have done it. I did request, it should go to a larger bench. But then that's how it is.
But the sentence is really tricky, as you have rightly pointed out in
Yes.
paragraph 34.
That's right.
The first sentence says that we are of the opinion that royalty is a tax.
That's right.
Then the last sentence of the same paragraph says
Not a
royalty
tax
on
on land,
not a
but a
tax.
payment for the user of land.
So,
And or there are earlier paragraphs also where they consistently say it's a user on return on the user of land. And they, but then that's how, this one sentence, it completely derailed the whole thing. Thousands, so many other judgments came which followed India Cement, and based on royalties, tax, the laws were struck down. Now, so that's how the mistake arose. And when we were arguing this matter, although in my case, Jharkhand royalty really doesn't come in, but High Court had relied upon India Cement and the other cases based on that. Therefore, the issue came up again, and Chief Justice Kapadia felt that how can 5 judges say that it's a mistake and correct it, should have gone to 7 judges, and that's how we have it. So now that we are before Lordship, it's unnecessary to decide whether they can or not. I don't mind, however, a Lordship can observe. I think it would be clearly permissible for a subsequent bench if it notices a clear contradiction and tries to harmonize the first and last sentence and says that if you just add cess on royalty, it becomes consistent with the whole. That's how much.
Actually, in what context royalty was held to be tax in the Mysore High Court judgment? It will be clear if it is seen that in that judgment what was actually imposed was a license fee.
License fee.
So if there was a discussion of the facts of the Mysore High Court judgment,
Yes,
then paragraph 34 probably may have been different.
that's right. There the issue was whether that license fee would be taxed or not.
Yes.
In fact, it was.
Held license fee is a royalty. The Mysore High Court judgment.
Yes, sir. So, however, since we are before a Lordship, that. Now, may I just show, if your Lordship has my written note, where I have extracted the sections involved, because in my case, from Jharkhand, so I will be defending Kesharam, but
Volume 1,
page 6. 1A. Yes, volume 1A. Can correct it. Actually, India's cement board sent all the states scurrying to find alternatives to recoup the loss of revenue. Finally, paragraph 4 at page 6. The old section I have mentioned, levy and assessment of cess subject to the provisions of this act and the rules framed under it, the authority shall by notification published. I'm sorry. Yes, old section 18. Subject to the provisions of this act and the rules framed under it.
just 1 second, Mr.
All of your lordships have got those?
For the
I'm in the same position as Justice Bhuiya, my lords. Computer.
Look at this. I mean, probably a year ago, this would have been unimaginable that everybody is on their laptops and. When you have a record like 30,000-40,000 pages, it would have been impossible.
Impossible.
Vodafone. Books have all gone from the court. Not that they are not used, but they are used in the digitized form.
don't think that there are no pretenders in the court.
I am one of pretenders. So I have 2 assistants who will help me out. And some of us have an added problem of getting headaches not by looking at the computer for too long. So may I place the whole section? No, this is not under challenge, just for historical purposes. Subject to the provisions of this Act and the rules framed under it, the authority shall, by notification published in the official gazette, levy a tonnage cess. I'm reading para 4.
Yes.
Tonnage cess assessed on the annual dispatches of coal and coke from each mine at the rates to be prescribed by the authority with the prior approval of the state government, provided that the rate of such cess shall not exceed 6 rupees per ton without the prior approval of central government. Provided further that the tonnage cess shall only be leviable until provision to the contrary is made by the parliament. Then there was a royalty cess also. An addition cess at the rate of 5% shall be levied and realized on the amount of royalty to be received by the state government. Additional cess realized under subclause 1 shall be transferred to the authority for the fulfillment of its object. Then this was amended with effect from in 1992. Levy, and this one is an issue. Levy of tax on use of land for other than agricultural and residential purposes. 1. The authority shall, subject to the provisions of this Act and rules framed thereunder, levy tax by notification published in the official gazette on land being used by any person, group of persons, company, the central government or the state government, local or corporate body for mining, commercial or industrial purposes with the prior approval of state government, provided that the tax so levied shall not exceed rupees 1.50 per square meter annually for any such land, but such tax shall not be levied on land which is subject to holding tax. The holding tax is identical tax paid on land by the agriculturalists. That's why the agriculturists have been excluded. 2. The state government shall, out of the tax so levied and collected, determine the amount to be deposited into the consolidated fund of the state government from time to time. In my case, the tax is not imposed on royalty, nor it is reckoning royalty, nor it is on the annual produce. It is directly, squarely on land and how land is bought and sold per square meter.
Qualified by the use of the land. It's on land which is used for commercial, industrial or mining purposes.
That's right. So that is to exclude the holding tax, which is already on agriculturalists. We don't want to burden the agriculturalists, and therefore that's excluded. Now, that was one issue, which is not referred to your lordships, which will be decided by the smaller bench when it goes back, namely whether it is a use tax. That was one finding which went against, which your lordships need not decide. But as far as royalty, etc. is concerned, this tax has nothing to do with royalty, nor its measure is based on royalty. It's a plain and simple, not exceeding 1.50 per square meter. Now, in para 6, I have mentioned the notification which was issued on 11th of February 1993, pursuant to the amended section 89. The rates were as follows. For industrial purpose, it was ₹1 per square meter. For commercial purpose, 1.25, and all other non-agriculture, non-residential purposes, other than
other than
1 and 2.
One small 1 and 2.
One is it. Other than 1 and 2. 150.
Yes.
In brief, my lords, at page 8, I have mentioned the findings of the High Court in my case, but I'll not reading it out, not necessary for the present purposes, but only thing is that they relied upon India Cement, State of Bihar, India Aluminum Company, and all those cases. Odisha Cement. Now, this having been done, my lords, your lordship may kindly have the constitution itself.
Please.
Yes, I was just wondering, because the lordship sees my learned friends know it's a matter of housekeeping. One of the things which the High Court said was that to the use tax and
That's what I told the court.
that is not a question referred to your lordship.
That's what he said. He said that that will have to be decided by a smaller bench.
By some.
But I'll take a lordship through first some of the entries which have directly a relationship with the issue. The first of them, my lord, is entry 23, list 2. So to start with, under the theme of distribution of legislative power, regulation of mines and mineral development is in the fold of the state legislature by virtue of entry 23, list 2, which reads thus: regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under the control of the union. To correlate it with list 1, as the lordships are aware, the entry pertinent would be entry 54. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by Parliament by law to be expedient in public interest. So the Parliament must make a law. That's the first prerequisite. And that law must contain a declaration that it is necessary that union controls in public interest. First law, second is declaration. The third is, which obviously it can't be a simple declaration and you can't take it out. It must lay down, the same law must lay down the extent to which the Parliament desires to control. In short, my lord, this entry is an abstracting entry. It takes out from the fold of the state completely. So to the extent, my lord, the prescription is there under entry 54, the field of the state under entry 23 gets denuded. So it's a pro tanto denudation. There's a cognate entry which is entry 53, which does not share the same interrelationship. It does not share the same interrelationship. Entry 53 reads regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. So this is an independent entry. Before the Constitution's advent of the Constitution, they were smudged into one under the 1948 Act, which I'll show to your lordships. But while the Constitution was approved, then they were segregated. And this was completely within the fold of the Parliament. Now, yet another, my lord, is which has a similarity will be entry 24 of list 2, which deals with other industries. Entry 24 list 2, which reads industries subject to the provisions of entry 7 and 52 of list 1. Now, 7 is industries declared by Parliament. I'm reading entry 7 list 1. Industries declared by Parliament by law to be necessary for the purposes of defense or for the prosecution of war. And 52 is industries, the control of which by the Union is declared by Parliament by law to be expedient in public interest. So that has some similarity with 54.
So both 7 and 52 require a declaration by law.
Both require law, both require declaration and
Public interest. Public interest.
Now, 52 doesn't use the word to the extent to which. In Ishwari Khetan's case, not and very rightly, they said that that is implicit. Entry 52 also, when you are making a law and you are abstracting, then how much you have extracted has to be specified in the law. So that was held to be implicit. Now, entry 56 also carries a similarity, but not pertinent. Now we come to the taxing entries, which are being relied upon by the state. The Lordship turns to entry 50, entry 49 and 50. Entry 49 is tax on lands and buildings. Now it is with respect to this entry 49, Lord, that observations have come that tax on lands and buildings should be directly on land as a unit. This expression as a unit will not occur on account of the fact that in list 1, entry 86, taxes on the capital value of the assets exclusive of agricultural land of individuals and companies, taxes on the capital of companies. So this expression, taxes on the capital value of the assets and land, is also one of the assets. So the issue, they were two competing entries in certain cases. And consequently, the court said that no, even if land is being included in entry 86, it is along with all the other assets. So therefore, it is a composite tax. Whereas tax on land and building in entry 49 is as a unit. Means as a unit, therefore, only connotes not that individually on land and building, not along with other assets which a party may be owning. In contrast to a composite tax under 86, it was a tax on the unit of land. My respectful submission, this word as a unit doesn't indicate anything else. Then we have lot entry 50. Taxes on mineral rights. Subject at least entry 50.
Yes.
Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. So based on this, two questions would be arising. What is this mineral rights? Would it comprehend within its ambit the leased area in which the mining is to be done, or which is peripheral? Because in every leased area, there is an area which contains minerals, but in order to excavate and carry it away, win it, and then dispatch it, you need some other areas, contiguous area, which is actually not containing minerals, to facilitate the activity of mining. So whether it will include that mining land and the peripheral area, if I may use this expression, peripheral contiguous area. The other question is, how do we understand this expression limitations? Does this expression limitation enable Parliament to usurp the taxing power? Or is it merely imposing some kind of a cap, maybe denial, don't impose? Can it usurp the power itself by making a law relating to mineral development under entry 54? This obviously alludes to, though not expressly mentioned, the last phrase, by law relating to mineral development will mean a law made under entry 54. which is not a taxing provision, but a general entry. And that's how, my lord, the other side raises this question that there is a departure from Sundara Ramayya's doctrine, which has been consistently followed and upheld. And recently, my lord, Justice Nagaratna has also delivered a judgment. It is in state of Karnataka versus Meghalaya. And in the 9 judges judgment in Jindal Steels. The doctrine of Sundara Ramayya is well entrenched, not departed from, dissented from by any learned judge in any case.
Which really postulates that the taxing entries are separately
That's
delineated in
right.
the
There is
schedule.
no overlap. One, that the taxing entries and general entries are separate. Two, that the taxing entries as between the two lists, 1 and 2, they do not overlap. So, and the third is that the general entry does not contain a source of tax. Now, positing this, would it be permissible, therefore, to say that this limitation, which will necessarily be imposed under entry 54, because if it involves usurpation of taxing power, then entry 54 becomes a entry which is, as the other side says, sui generis, or it stands apart from the general structure and division of powers.
Question is whether a taxing power can be read into a general entry.
That's right.
Slightly.
That's right. By extending something from the taxing entry in list 2, we make the list 1 entry a taxing entry, which is actually a general entry.
The consistent position in law is that the power to tax is identified separately in the list. Therefore, a general entry in the list will not include within it a power to tax.
Yes. So therefore, this limitation can only means putting a limit, because minerals are very important. No dispute between the parties here. They will also emphasize. I'm also conceding. Minerals are very important, right from defense down to so many other things. The infrastructure industry, every industry needs steel and iron and so ingots and. So therefore, minerals rights are certainly very, very important. And in this respect, I will be showing to your lordships an important aspect from the Constituent Assembly debates. For the present, your lordship may just make a note of that, then that is that there was a motion moved by one of the members that entry 50 should be deleted from list 2 and kept in list 1. But Dr. Ambedkar rejected it. So if the framers had wanted that there should be a taxing power on mineral rights with the parliament, the easiest thing was to accept that and move it from here to there. Not to move that means that no, state will continue to have the power, but since it is of national importance, minerals, therefore, parliament has a reserved power to say, to cap it. So that the states don't go berserk and they start competing and raising taxes beyond limits and extraordinary limits. So this limitation word, if grammatically understood, will not indicate usurpation, arrogation by parliament. Contextually also, it will not indicate that. And if we keep in mind the Constituent Assembly debates, it will not mean that. So whereas, my lord, now there is a fourth doctrine that all the entries must be liberally construed. But that will not mean that the limitation which is imposed has also to be so liberally construed as to completely denude the main part of it. Just as in the case of provisos, we say that proviso cannot eat up, the ear cannot rise higher than the head. So the entry has to be liberally construed, but the limitation or restriction has to be construed naturally, by natural words, whatever they mean. I am not saying that you squeeze the scope of limitation. Whatever it may naturally mean, grammatically mean, should be attributed to it. So there is a balance. In that sense, one may say it's a unique entry, though I don't see, I'll show some more entries of similar kind. There's nothing unique. This distribution of legislative power involves balancing. Something is put there, something is here. The tilt is in favor of Parliament, both here in the distribution as well as in 246. That if ultimately, as my Lord Justice Nagaratna said, or in that judgment, that if there is a clash and conflict which cannot be resolved, cannot be harmonized, then state has to accede to the scope of Parliament's power. But when we construe the entry, my Lord, then it cannot have, the limitation or restriction cannot be expanded so as to eat up the legislative field itself. To render the entry yet another aspect is, my Lord, should not this limitation, limitation in the law made by Parliament be express, specific, and concrete? Not by inferences that Parliament has MMDR Act, we read and we say that even though there is no provision which is restricting entry 50 by imposing a tax on mineral rights or a limitation on tax on mineral rights, yet we say that somewhere we find royalty, therefore this is out. So the limitation, Parliament must apply its mind, consciously impose specific and express provisions in its law in order to limit it. It should not be difficult for Parliament to say that the tax imposed under entry 50 list 2 will not go beyond this. The submission will be that please understand limitation as something which is an express, concrete, specific provision.
But this limitation will be only in terms of quantum of tax.
Could be anything. I'm not saying squeeze it, but it should be something which is limiting. It can be in the form of principles that this formula will be applied. It could be just anything without meaning to be exhaustive about it. It could be anything which tells the state, do it in this way, don't do that. The do and don't both can come in.
In the context of mineral development,
Mineral,
to encourage certain minerals to be extracted.
yes.
For the initial years of a lease, there could be a tax holiday.
Could be, no? They can say that for 5 years you will not impose a tax.
Yes.
They may even say, my Lord, that let's say some war is going on, my Lord, and for this interregnum period you will not have it. So I don't mean to be exhaustive. All I mean to say is in the negative sense that you can't expand limitations so as to say that not the state, Parliament will. That's my limited purpose of.
So first principle remains.
Yes.
You have to enact a law, and only by enacting the law you can limit. It can't be a matter of inference.
No. So
Or
it has to be
interpretation.
specific, express. We will not derive it from the nooks and corners of MMDR Act, my lord, that there is a limitation on this.
The limitation which Parliament can impose is a limitation in the interests of mineral development.
Yes.
Not expressly a limitation on the taxing power only, but Parliament may well come to the conclusion that a limit on the taxing power of the states is necessary to ensure
For
mineral
mineral
development.
development. I stand corrected.
So it's not in that sense a taxing and the taxing power of the state which is restricted by a taxing power of the union. It's a taxing power of the state which is restricted by the general regulatory power of the union in that area.
And this entry itself says by law relating to mineral development. In other words,
Government is in the interest of mineral development.
correct.
That imposes a restriction on the taxing power of the state.
So if, correct, Manoj. Now if, I agree with that. Manoj. Now, Parliament need not expressly say that it's doing so in the interest of mineral development because it is making a law which is in the interest of mineral development. But it must have a provision which is clear, specific and express, and intention is clearly flowing that it intends to limit this taxing power of the state. The bottom line is
mineral development. What is the concept of mineral development?
Like mineral development will also involve conservation of minerals. How much mineral is to be extracted? It will also involve in what manner the minerals are to be used. Because now there is a intergenerational right concept introduced. This got internationally accepted. So
the quantum of mining which can be carried out.
Yes, quantum of mining.
The bearing capacity.
That's why it requires a mining plan. Then ecological impact of it, what is happening. So that's why we require a certification from the Environment Ministry. If there are forests, that has to be. So all this balancing will be part of mineral development.
Could be a restriction on export of certain minerals.
Export of minerals, export
Even
to
if it's
this, not to
extracted only for domestic consumption.
Yes, consumption. So that may be the width, but what I understand from my Lord Justice Oak's question was that independently of what we understand by mineral development. So, for example, my Lord, when we extract iron ore, then there are blue fines, as we call it, the dusty, then all that is, and there are lumps also. So then you have to bring it to particular sizes. So beneficiation. So we'll come to that. So there are specific provisions in the MMDR Act in this respect. How to, and they are, again, as I said, it's for Parliament and for the experts to decide to what extent it can't be, we can't define this word in a manner which makes it rigid. We have to leave it to the times as economics develops, as the industry develops and as the needs arise. But ultimately, the law which is made limiting, the limitation itself has to be in the interest of mineral development. And as I respectfully submit, the bottom line is, whatever limitations you wish, temporary, permanent, long-term, short-term, you can't usurp. You can't say, I will be imposing the tax. You may go to the extent of don't impose. The interest of mineral development may be a price factor because international prices are going up. So national prices, you have to do all sorts of balancing in economics. So you may say, stop, don't do it, don't impose, temporarily or permanently, whatever. But you can't say, I will impose.
Because taxes on mineral rights are not assigned to, they're not, it's not a subject which is given to Parliament. It is exclusively within the competence of the
Exclusively.
legislature of the state.
So in that sense, the entry seems to be, one may say that it's different from the other plain, simple entries like tax on land and buildings. But the power is exclusively within. Now read this with 246(3). Any idea of usurpation goes against the grain of 246. Subject to clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to the matters enumerated in list 2. So any idea of usurpation goes against the grain of this exclusivity.
At the same time, you have to see what in pith and substance is the imposition.
Yeah, that can always be seen. Because labels will not decide the substance. Pith and substance doctrine will have its play. But at the moment, I'm only trying to question this possible submission which is being made and earlier made in cases that because of MMDR Act and because there is Section 9 royalty, therefore, my lord, this is denuded. Or the other submission that once a complete code is there under entry 54, therefore 50 is ousted. That cannot happen. And entry 50 cannot go into entry 54. Parliament cannot itself impose the tax under entry 54. For that's one, that's not a taxing entry. Second, Constituent Assembly rejected the shifting of entry 50 to list 1.
Just one thing. Entry 54 of list 1 is not a taxing entry.
Non-taxing entry. And secondly, the Constituent Assembly rejected the shifting of entry 50 to list 1. Thirdly, entry 50 is the exclusive power of state. Fourthly, limitation word by its very nature, considered naturally and grammatically, not result in abstraction of taxes on mineral rights into the fold of Parliament.
Interestingly, in 54,
Yes.
as the Chief Justice just now was commenting, regulation of mines and mineral development is there in 54,
Yes.
and in 50 also,
Yes.
Parliament by law relating to mineral development. So
That-
this expression is used twice
That's right.
in both list
So
1 and
this,
list 2.
this indicates that limitation must
Limitation
come
is-
under entry 54. It is the same kind of law which is contemplated. Whatever law Parliament will make, it will make either with respect to list 1 or list 3. So this word of limitation is not is independent empowerment of Parliament to make a law, but is an allusion to the law which the Parliament can make by virtue of the entries in list 1 or list 3. Otherwise, we will,
Parliament can really, in that sense, impose a restriction on the taxing power of the state. But the taxing power still continues to vest with the state,
that's the humble submission.
always.
Of list 2
Yes,
is also subject to entry 54 of list 1 because they are the same with regard to mines and mineral development, but
I oblige.
subject to
Subject matter is identical.
but subject to list 1,
That's right.
entry 54.
That's right. So law will be under list 1. The only difference, Lord, with if we compare 23 with 50 is that 23 does not use the expression subject to any limitations imposed there. The entire entry is subjected.
It is subject to the provision.
Yes. Whereas here it says subject to any limitations imposed. That's a contrast between the two. I'm grateful. Mulch. Now, this entry, Lord, in no way, entry 50 list 2 is not in any sense unique. Kindly have 57. Taxes on vehicles, whether mechanically propelled or not, suitable for use on roads, including tram cars, subject to the provisions of entry 35 list 3. So here again we find a taxing entry in the state list which alludes to or which is subjected to list 3, which apart from fee doesn't contain a taxing power. Kindly see entry 35 list 3. Mechanically propelled vehicles, including the principles on which taxes on such vehicles are to be levied. So although both state legislature and parliament can make law with respect to list 3, but parliament has an overriding power. But while making a law, parliament with respect to entry 35 can only lay down principles.
Yes. 63 of list 2.
63 of list.
Rates of stamp duty.
Stamp duty in respect of documents other than those specified in provisions of list 1 with regard to rates of stamp duty. Entry 91
of list 1.
1 of list 1. Rates of stamp duty in respect of bills of exchange, checks. But in case of this 91 and 63, once these documents are actually out of the fold, only parliament can impose tax. Whereas so far as 50 and 57 are concerned, the power of parliament is limited. In one case, limitation word is there, in other case, general principles. Yet,
Interestingly, on stamp duty,
yes.
the main provision is in the concurrent list, entry 44 of list 3. Stamp duties, other than duties or fees collected by means of judicial stamp, but not including rates of stamp duty. And why is rates taken out of entry 44? Because the rates in respect of some documents are introduced in the union list. Rates in respect of all other documents are introduced in the state list. But the power is a concurrent power.
But if the states have imposed some rates, Parliament can override that.
In respect of
Rates.
right. No, but Parliament can't override the rates at all. Power to impose rates is exclusively assigned to the state, except in respect of the excluded entry.
Not including the rates of.
But the power to levy a stamp duty is given both to Parliament and the states.
Now, kindly also, there's another interesting entry in list 1, which is 32. So it's a general entry. Property of the union and the revenue therefrom. Have this entry 32.
Yes.
And the revenue therefrom, but as regards property situated in a state subject to legislation by the state, save in so far as Parliament may by law otherwise provides.
Exception to an exception.
Ordinarily, it's the states, but if the Parliament does not want the states to do that, then it provide otherwise. So all this provision otherwise, and the reason for alluding to this is that Parliament by law otherwise provides, again, these have to be specific, concrete, expressed. They can't be by inferences, by mere implications. At best, there should be a strong implication.
Another interesting aspect which would support your submission is entry 97 of the residuary entry.
Yes.
Of list 1, which says any other matter not enumerated in list 2 or list 3, including any tax not mentioned in any of the lists. So if a tax is mentioned in any other list, then Parliament can't exercise the residuary power of legislation to enact that tax.
Even under 97, it cannot. This has to be read with Article 248. 48 is pertaining to the residuary powers. (248) reads this: subject to Article 246A, Parliament has exclusive power to make laws with respect to any matter not enumerated in the concurrent or state list. The 246(3) exclusivity, 248(3), they're all consistent. 97.
Section 2 of Article 248 is more pertinent.
Such power shall include the power of making any law imposing a tax not mentioned in either of those lists. So not only the field of legislation, but which has to be read with the power under 248, read along with that, is indicative of the fact that there is no arrogation of taxing power reserved for the state contemplated. So the scheme of Sundara Ramaiah, as endorsed by subsequent judgments, stands reinforced rather than diluted by entry 50. And all these expressions of subject to, etc., not including this, excluding that, these are meant to balance, and distribute the powers, the larger national interest and state interest. And to complete this chain, a lot of thought with regard to entries, there's a doctrine developed by this court, and that is with respect to federalism being a basic feature of the Constitution. And that is a doctrine which applies in a limited way. Ultimately, federalism has two parts, both the center and the state. But what this doctrine evolved by this court says is that don't expand the phraseology so as to deprive the state of its taxing power or any other field of legislation. If the subjection to the parliamentary domain, parliamentary legislative power, is clearly and specifically flowing, it has to be honored. So that is the scheme of the Constitution. But if there is that doubts or ambiguity, etc., then the effort should be to preserve the state's power rather than rule in favor of its denudation, which I will show one of the judgments. So that one completes the entry and
also, Mr. Dwivedi, the doctrine of occupied field does not really apply in a conflict or where the subjects are in list 1 and list 2. The doctrine of occupied field, where the mere enactment of a law or the failure of parliament to enact a law has no bearing on whether the states should or should not legislate. If it's an occupied field, then by virtue of the fact that it is occupied by law made by parliament, the states are completely denuded. But that's only in respect of list 3.
So, yes, this expression occupied field, your lordships have deployed in two senses. One is list 3, where your lordship says that if the parliament has exhaustively covered the entire field with regard to a subject matter, then states cannot trench upon that field. And if the states have already made a law in that, then it will survive only to the extent it is not repugnant, and Article 254 becomes the key to resolve it. And the other is, this expression has been used is in the context of entry 23 and 54 and 24 and 52, where your lordships have said that if Parliament has made a law with regard to mines and mineral development, and that covers the whole field, then the states cannot. So much so that if regarding minor minerals, Parliament doesn't itself, but it contains section 15, which says the states will make rule on these subjects regarding minor minerals. So the states must act as a delegate under section 15. It cannot make its own law. So it's in that sense, that this expression has also occurred and repeatedly deployed. All that your lordships have warned is that we must clearly demarcate whether the field is covered or not. So whenever somebody says that this field is completely covered by MMDR Act or any other oil offshore mining act, then one has to read that act and see that what the state has done, is it occupied there? If it's not occupied, then state's law is good.
So it says to the extent to which.
To the extent to which, I'm reading. I'm sorry, but one more provision I need to show. 6, Article 286. I'm more concerned with 286.3, but I'll read the whole of it so that the context is clear. 286(1), no law of a state shall impose or authorize the imposition of a tax on the supply of goods or of services or both, where such supply takes place A, outside the state, or B, in the course of import of the goods or services or both into, or export of the goods or services or both out of the territory of India. Then 2, Parliament by law formulate principles for determining when a supply of goods or services or both in any of the ways mentioned in clause 1. Now 3 has been deleted subsequently in 2016. But if your lordships will look at the footnote 4, I hope your lordship
Yes,
there.
got it. It's there.
Clause 3 omitted by the Constitution 101st Amendment 2016 with effect from 16 September 2016 was substituted by so and so. 3. Any law of a state shall, in so far as it imposes or authorizes the imposition of a tax on the sale or purchase of goods declared by Parliament by law to be of special importance in interstate trade or commerce, or B, a tax on the sale or purchase of goods being tax of the nature referred to in subclause B, C, D of clause 29A of Article 366. Be subject to such restrictions and conditions in regard to the system of levy, rates, and other incidents of the tax as Parliament may by law specify. So, entry 54, if it is a good, particular good is declared to be of special importance, then it will be subject to restrictions and conditions, which issue did arise in this court, and lordship said the restrictions and conditions must be specific, express, and concrete. Otherwise,
It has no bearing on what your argument. Look at clause 2 of 286. It doesn't make sense now. Just see, it says Parliament may by law
formulate principles for determining when a supply of goods or services or both in any of the ways mentioned in clause 1.
So it's, what happened was, now see footnote 33.
Yes.
The original word was sale or purchase of goods takes place. While making the amendment after the GST legislation was enacted, they deleted the words takes place. The words takes place should have been retained in clause 2.
Yes.
Otherwise, clause 2 has no meaning now. As Mr. Harris, it's a fossil. But,
yes.
But they, by mistake, the draftsperson took away the words takes place also from 286(2).
But maybe by formulating principles, it can be brought back.
Formulate principles for determining when. And they said now supply, because in the GST legislation, it's not sale or purchase, it's supply. Yes. But you had to put the word takes place. Takes place is just taken away. Anyway, you referred to 286(3 then.
I refer to it because I'll be relying upon a case which is directly on this note to say that there should be specific and later.
What next, Mr.
Now, I would like to place the Mines and Minerals Development Act notice, because that's a law made by Parliament, which is immediately in issue.
Is it already in a digitized form? Sorry.
I don't think there's anything he has said which is controversial. What I've heard. Some jurisdictions, they say in a case like, please lead counsel, sit down together and formulate a list of propositions or laws to which you are all agreed. So then one of them reads it and that's it. And then focus your submissions on what you don't agree on.
So I think we can do that. We've also taken down what Mr. Dwivedi has said.
No, like my friend is arguing. We should all say we agree to all this. You don't need to go over a lot of.
So perhaps on your side, you could tell us tomorrow, at least we can implement it in part, so that you would have, now anyway, we've taken an hour plus. On what are those propositions about which there is no real dispute
Absolutely.
over here on this side completely.
Maybe after I finish, they may not dispute anything.
Which make it quite possible because we are actually running on parallel tracks.
I have Kesharam to defend.
Yes. Is the MMDR Act in the digitized form also, or
Volume 4, page 910.
has all the statutes as well?
48. Kindly first have page 891, my lord. There was a predecessor act which will have some relevance.
You're showing 48, right?
48.
91 in the
Yes.
volumes. PDF.
Now, this was a law made by the Constituent Assembly itself, acting as the parliament,
parliament
under
at that
the
time.
India Independence Act 1947. And it was exercising all the powers which was earlier being exercised by the Governor General in Council. Because the Government of India Act 1935, to the extent of federation, never came into existence.
Right.
So the Government of India Act 1919 continued, and the powers of the Governor General in Council were the same there. So all those powers vested and read with India adaptations under the India Independence Act. This law was made. Received the assent of the government. It's a short law, received the assent of the Governor General on the 8th September 48 and is published in the Gazette of India Extraordinary dated 8th September 1948. An act to provide for the regulation of mines and oil fields and for the development of minerals. Whereas it is expedient in the public interest to provide for the regulation of mines and oil fields and for the development of minerals to the extent hereinafter specified, it is hereby enacted. This act may be called the Mines and Minerals Zone, so it extends to all the provinces of India and also to any exceeding states for which the central legislature has, for the time being, the power to make law development of minerals. Now, Lord, you see that both oil fields and that, they are covered by this. Same, they were not separately dealt with. Section 2 contains a declaration, but it could not be a declaration under 54 because Constitution was not there, my lord, and that was one of the problems in. Oh, I'm so sorry. Yeah. The Lordship will notice, not historically significant something that it says that provinces of India and to exceeding states. By this time, the issue of accession had not been finally settled. It's September, and this Hyderabad and Junagadh and Kashmir issues were still alive.
Yes. Very interesting. Actually.
Yes. So they say exceeding states, and they also say has for the time being the power, because some states which had exceeded, they had exceeded only on 3 subjects, and some had already stated that they accept the constitution which is coming. So these variations are taken care of.
1950, January 26.
Yes. In fact, Goa came much later. Goa was probably
Dadra and Nagar Haveli.
Dadra and Nagar Haveli and all that. 60s, yeah. The third 3 is the definition. And you'll also see C, minerals includes natural gas and petroleum. But now under the MMDR, they have excluded it and separate. Oil field is in E. Then 4, 5, we can kindly have 6. both 5 and 6. The central government may by notification in the official gazette make rules, I'm reading section 5, for regulating the grant of mining leases or for prohibiting the grant of such leases in respect of any mineral or in any area. But that was those times, the idea was that investments were not there in the private sector, so state had to do it, so they could prohibit also. Even today, the state and central government can reserve. In particular, without prejudice to generality of foregoing power, such rules may provide for all or any of the following matters: A, manner in which the mineral or areas in respect of which by whom applications for mining leases may be made. B, authority by which the terms on which and the conditions subject to which mining leases may be granted. C, the maximum or minimum area and the period for which any mining lease may be granted, and terms on which lease may be granted with respect to contiguous area may be amalgamated. Fixing of the maximum minimum rent payable by a lessee, whether the mine is worked or not. Then 6, central government may by notification in the official gazette make rules for the conservation and now kindly have I, section 6I. The levy in fellowship has section 6I.
6I. Review of
The levy and collection of royalties, fees, or taxes in respect of minerals mined, quarried, excavated, or collected. Now, this is significant because both powers were with the central government. By exercising a rule-making power, it could fix both royalties, fees, and taxes in respect of minerals. Section 7 pertains to modification of the existing leases. Under section 10, it had to be laid, the rules had to be laid before the legislature, central legislature. A matter of some interest, section 13, that even the crown was found because at that time we were dominion, not yet declared to be a republic. So the crown was also. Sorry?
There's an error. Whether last part.
Yes,
This
is the time.
That's it. There are two typos in fact. After or also.
Yeah. Why?
of section 6, I is that royalty and tax are both mentioned and as powers to be exercised by central government.
Yeah.
Its significance will arise when the Lordship sees section 25 of the present act, which talks of recovery of taxes. Because one of the questions was that section 25 is talking of recovery of taxes, but there is no provision imposing tax. So unless you treat royalty as a tax, the connection snaps. So the reason for mentioning will be evident not even once I place. This explains why section 25 has the word tax. Now kindly have the main act which is still operating. That is MMDR Act 1957. Volume 4, page 910. the Lordship has the bare act, not that will be containing other rules also. Kindly see, I'll only point out the relevant provisions. Section 3AC is the leased area. The declaration is contained in section 2. Now, this declaration will be under entry 54. AC is the leased area, means the area specified in the mining lease within which the mining operations can be undertaken and includes the non-mineralized area required and approved for the activities falling under the definition of mine as referred to in clause I. Now, AE is mineral concession, which is very widely worded, includes mining lease, reconnaissance permits, prospecting license, composite license, and all this. Small c is mining lease, means a lease granted for the purpose of undertaking mining operations, includes sublease. D is mining operations, means any operation undertaken for purpose of winning any mineral. And FA is production, or any derivative word of the word production, means the winning of or raising of mineral within the leased area for the purpose of processing or dispatch. You can leave out for definitions of prospecting, etc. By virtue of section 4, all mining has to be done under licenses, permits, and lease. Section 6 is maximum area. 7 is periods, 7 and 8. Now, 8 is the new provision which now requires that initial leases will be of 50 years, the rest all by auction. Kindly come straight to section 9. The holder of mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or in any law in force at such commencement, pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sub-lessee from the leased area after such commencement at the rate for the time being specified in the second schedule in respect of that mineral. The holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of that mineral. So both old leases and the new leases will be subjected to charge of royalty. The only exception with regard to coal is 2A, that to the extent the workmen consume coal for their own purposes, subject to limitation, royalty will not be charged. And 3, subsection 3 says, the central government may by notification in the Gazette amend the second schedule so as to enhance or reduce the rate at which royalty shall be payable in respect of any mineral with effect from such date as may be specified in the notification, provided that the central government shall not enhance the rate of royalty in respect of any mineral more than once during any period of 3 years. So that then is the provision of royalty, and 9A.
Royalty is not defined under that.
No,
It's not defined.
no. All that it says is that royalty is in respect of minerals which are removed or consumed from the leased area. If your lordship looks at the second schedule, your lordship will find various, just a glance, we are not referring to any particular mineral here. The second schedule has a detailed list of different minerals, different rates ad valorem. The question, my lord, one of the question is whether this royalty which is levied under section 9 is in the nature of tax, either on a plain reading or by, my lord, bringing in Article 366(28) of Constitution, which says, which can be seen at this stage. Tax,
That's the main question. Yeah.
that's,
Everything revolves on nature of the royalty.
that's right. Tax or impost is the word used there. So how do we understand this word impost? Kindly have a look at section 366,
Section 36.
Article 366, 28. Taxation includes the imposition of any tax or impost, whether general or local or special, and tax shall be construed accordingly. So one question is, how do we look at this word imposed as something completely different from the word along with which it occurs, namely that it should be in the nature of a tax. And the other would be, Lord, that irrespective of the label or the nomenclature which is used, because this issue has arisen, Lord, several times, whether it's cess, which is it a fee or is it tax? Is the fee in the nature of tax or tax in the nature of fee? So
The implication of holding it one way or the other.
if the lordship holds that royalty in section 9 is a tax, then the next step which the respondents take is that royalty is with respect to minerals removed or dispatched, so it has connection with the minerals, the mineral rights, and consequently it will be a provision which is a limitation within entry 50. That will be one inference with regard to royalty. So it will be, therefore the question arises, if we treat this as a tax, then it becomes a case on a plain reading of 9, 1, 2, and 3, where Parliament has arrogated to itself the power to impose tax. It's not imposing any limitation. You will not do it, I will do it. That's the consequence of considering it a tax. 3 says only central government by notification can amend the schedule so as to enhance or reduce. So the Parliament then will not be limiting the state's power, but will be assuming the power to itself to fix, enhance, to reduce. That's how the word limitations, the ambit of the word limitation itself becomes an issue. And this is quite apart from the fact that the expression royalty has been used even in the 48 Act, when the Parliament was mentioning both royalty and tax side by side.
Right.
But now your lordship will not find any provision which imposes a tax, does not use except in the case of recovery, that is section 25. It was necessary to have the word tax in section 25 in a recovery provision alone because 1948 Act had empowered the Parliament to, central government to impose tax also. And it was possible that there are taxes due when this new Act comes into force. So the recoveries would still have to be made up with respect to those tax dues. And consequently, only tax is there.
This is the next provision you want us to see.
Only one thing, section 20, for 25 says, tax fee or other sums due to the government under this act. Can't go to the old act then.
Subsection 2.
No, subsection 1 of section 25 says, tax fee or other sums due to the government under this act,
Yes.
not under the old act. Not empower recovery of outstanding tax under the old act.
So I'll just show to your lordships, immediately straight away, kindly see section 29.
Yes, existing.
Section 29 continues the existing rules, my lord. So as if they are made under, as if this act has been in force on that date. All rules made or purporting to have been made under the Mines and Mineral Regulation and Development Act 1948 shall, insofar as they relate to matters for which provision is made in this act and are not inconsistent therewith, be deemed to have been made under this act as if this act had been in force on the date on which such rules were made and shall continue in force unless and until they are superseded by any rules made under this act. So those the rules under the 48 Act were made in 1949. So they were continued. This act itself came in 1957 after the first elections.
Yes.
And the rules, as the lordship are aware, were made in 1960. Mineral Concession Rules 1960, which repealed the old rules. So that appears to be the only intent of 25. Otherwise, it's a recovery provision, as the lordship will see on a plain reading. It says, any rent, royalty, tax, fee, other sum due to the government under this act or the rules made thereunder or under the terms and conditions of mineral concession may on a certificate of such officer may be specified, be recovered in the same manner as an arrear. It's not a provision. 25 doesn't impose a tax.
Recovery provision.
Recovery. And it's an omnibus provision, so whether doesn't take care of what is due or not due, it comes together everything and gives a wide power for recovery. But the tax imposition has to come by some specific provision. And royalty is something, Lord, there's one concept, Lord, which in Gannon Dunkerley, which your lordship deployed. Namely, Lord, that if a particular expression like sale was being commonly used and understood in a particular manner in the sense of sale of goods act. So therefore, wherever this entry 54 of the word sale was understood in that sense. Likewise, royalty, Lord, was not something unknown. This was being recovered. In fact, one finds mention of this in even Kautilya's Arthashastra. The Iron Age came much before, so mining is not that was unknown to India, only after the Britishers came. So, with respect to, one clearly understands, state is the owner of the minerals. There's no dispute again. I hope so. Unless and until, my lord, the land, etc., is acquired specifically by Parliament under some law.
No, there may be a dispute where the land is a patta land. Again, is a controversy.
Then there is a private person who will be owning. And that is a very important aspect which I am relying upon. Royalty is a tax. And if state is mining on a private person's land, then it has to pay royalty to that private person. So is the state or the central government not paying royalty tax to the private person? Royalty, therefore, is consistently used in the sense, prevailing sense, namely that it is a return for parting with my ownership right to the lessee. I can mine, the state and the government can itself mine, extract minerals and sell it. Instead of doing itself, it grants a lease. And under the lease, the lessee then assumes that right. And a lease is nothing but a contract.
What happens if the owner of the land himself mines?
Then no royalty, it
No
won't be.
royalty is due.
Yes. But if it transfers that right, then it says, all right, you will be selling, you will be earning profits. So I must get it. Just like, if I author a book and I give it to a publisher, I transfer my copyright to the publisher and the publisher earns profit on that by publishing a number of copies. So I say that I must get as an owner. It's no different. And that's how it is used. Now see also 9A, which is dead rent. A, dead rent. It is intricately connected with royalty because if somebody doesn't mine, even then he has to pay dead rent. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Regulation and Development Amendment Act 1972, shall, notwithstanding anything contained in the instrument of lease or in any other law for the time being in force, pay to the state government every year dead rent at such rate as may be specified for the time being in the third schedule for all the areas included in the instrument of lease.
Yes.
Then proviso is important. Provided that where the holder of such mining lease becomes liable under Section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area, he shall be liable to pay either such royalty or the dead rent in respect of that area, whichever is greater. So if the mineral dispatched result in a royalty which is lesser than the dead rent, then you have to pay dead rent. If you don't mine at all, you still have to pay dead rent. So that's the price which I am asking for myself, for them, namely the state, because the land has mineral and has been given to you for purposes of certain activity. So dead rent assures a minimum return and royalty may be a higher return or a lesser return. But only one of the two is payable, whichever is greater. Just to note, kindly just note section 13, which is the rule-making power of the central government. 13(2)(I). Empowers rules for making of rules for regulating the grant of mineral concession. And then 2(I), some specific illustrations. One is, I is the fixing and collection of fee for mineral concession, surface rent, security deposit, fines or other fees or charges, and the time within which and the manner in which the dead rent or royalty shall be payable. So the manner, the rate is etc. fixed under 9, dead rent under 9A, the manner of payment. Now section 15(1)(a) small g is for minor minerals and the state has power to make rules. Kindly have section 17. As the caption of above section 17 shows, it's a special powers of central government to undertake prospecting or mining operations in certain cases. Subsection 1 of section 17 says provisions of this section shall apply in respect of land in which the minerals vest in the government of a state or any other person. Then kindly have 3. Where in exercise of the powers conferred by subsection 2, the central government, I'm sorry. Where in exercise of the powers conferred by subsection 2, the central government undertakes reconnaissance, prospecting or mining operations in any area, the central government shall be liable to pay reconnaissance permit fee or prospecting fee, royalty, surface rent or dead rent as the case may be, at the same rate at which it would have been payable under this act if such reconnaissance, prospecting or mining operations had been undertaken by private persons under a mineral concession. Now, if we treat royalty as a tax, then it will be a strange case of the government paying tax to the private person. Therefore, royalty under this act cannot be understood as tax. It has to be understood as a return. Because the land belongs to and mineral belong to the private person, you have to recompense him by paying a return which you are yourself charging. The only difference will be that royalty is not being fixed by the private person, but under section 9. But that's a matter of regulation. Now 17 capital A, reservation of area for purposes of conservation. Central government, with a view to conserving any mineral and after consultation with the state government, may reserve any area not already held under any prospecting license or mining lease, and where it proposes to do so, it shall by notification in the official gazette specify the boundaries of such area and the mineral or minerals in respect of which such area will be reserved. 1A, the central government may, in consultation with the state government, reserve any area not already held under prospecting license or mining lease for undertaking prospecting or mining operations through a government company or corporation owned or controlled by it, and where it proposes to do so, it shall by notification in the official gazette specify the boundaries of such area and the mineral or minerals in respect of which such area will be reserved. Now with this, if your lordship sees 2A, where in exercise of the powers conferred by subsection 1A or subsection 2, the central government or the state government, as the case may be, reserves any area for undertaking prospecting or mining operations or prospecting operations followed by mining operations, the state government shall grant prospecting license, mining lease or composite license as the case may be in respect of such area to such government company or corporation within the period specified in the section. Now, having got this, kindly turn to advert to subsection 3.
Important.
Although 2C also envisages some payment on account of this, but pertinent is 3, subsection 3, where in exercise of the powers conferred by subsection 1A or subsection 2, The central government or the state government, as the case may be, undertakes prospecting or mining operations in any area in which the minerals vest in a private person, it shall be liable to pay prospecting fee, royalty, surface rent, or dead rent, as the case may be, from time to time at same rate at which it would have been payable under this act if such prospecting or mining operations had been undertaken by a private person under a prospecting license. Where the minerals are vesting in the private person. It makes sense that if it is a return for the parting of the ownership right to extract minerals and sell them, then it's a consideration virtually. As in the case of Excise Act, they say that it was a privileges part, or in the case of Spectrum, owned in trust by the central government. So they can charge call it license fee, royalty, etc. They are all considered to be consideration. For a share, I would put it as a share in the mineral value. My Lord Justice Oak was asking about mineral development. There's something in section 18.
Right, correct.
Whole chapter begins with this development of minerals. Opening of new mines, excavation, collection of minerals taken by owners of mines for purpose of beneficiation, new borings, shaft sinkings. It's understood in a slightly wider sense. And we have section 21, of course, is penalty, but somebody unlawfully mines. Under subsection 5, he will still be subjected to payment of rent, royalty, or tax, as the case may be. Now, this again, my lord, is a recovery provision. And here, my lord, after the word tax, your lordship will find as the case may be.
Where, Mr. Advedi? 21?
21(5).
Right.
Whenever any person raises without any lawful authority any mineral from any land, the state government may recover from such person the mineral so raised, or where such mineral has already been disposed of, the price thereof, and may also recover from such person rent, royalty, or tax, as the case may be. Then is section 25, which is one of the provisions relied upon by the respondents. Some of them are appellants, but I'm using this expression generically on the other side. Any rent, royalty, tax, fee, or other sum due to the government under this act or the rules made thereunder or under terms and conditions of mineral concessions may, on a certificate of such officer as may be specified by the government in this behalf, by general or special order, be recovered. So just like that other provision, this is also in 1972, this subsection 2 was substituted. Any rent, royalty, tax, fee, or other sum due to the government either under this act or any rule made thereunder or under the terms and conditions of any mineral concession may, on a certificate of such officer. So again, a recovery provision after 72, but it continues to use the word tax. The nature is recovery. 29 I have already read. And 33 may be seen, which is also last section, Act. All acts of executive authority done, proceedings taken, sentences passed under the Mines and Minerals Act 1948 with respect to regulation of mines and development of minerals during the period 26 January 50 and ending the date of the commencement of this act, the government or by officer of the government or by authority in belief or purported belief that the acts, proceedings or sentences were being taken or passed under the said act shall be valid and operative as if they had been done, taken or passed in accordance with law. So even if there was some irregularity or something, there's still. Now, apart from this, there is no other provision which levies specifically any tax. The lordships have seen that royalty is payable even by the government to the private person, which is something which India Cement did not note at all. Now, just one rule, mineral concession, lordship will find page 897, volume 4. One 1586.
In the same volume, I think.
I'm sorry, page 1586. Volume 4. Kindly have rule 64, capital A, which is only. Which किसने 64? Hearing वाला कौन सा 57? Authority, my lord, is the central government. Kindly see chapter 4 of the Mineral Concession Rules 1960. At page 1595. Please see the caption, grant of mining leases in respect of land in which the minerals vest in the government. Then please advert to Rule 27. C, 1C, 27 1C. The proviso. Proviso says, provided that the lessee shall be liable to pay the dead rent or royalty in respect of each mineral, whichever be higher in amount, but not both.
27, is it?
Yeah.
27. 1601.
Yes, 1016.
601.
1601.
Before D is important. Very important.
May I continue after lunch?
Continue after that.
Because during the course of the lunch, first session, I have gained a case, so
Sorry?
I have gained a case.
Oh,
I will also be appearing in 901 with
901.
0.44, state of Odisha.
Yeah, 901, oh?
901.44. PA number 1883 of 2006.
Yes.
I had shown chapter 4 of the Mineral Concession Rules 1960. Now, if your lordship turns to chapter 5, at page 1608, volume 4. The heading shows the procedure for obtaining a prospecting license or mining lease in respect of land in which minerals vest in a person other than the government. Forty-one elaborates that the minerals vest exclusively in a person other than the government. Rule 45, I, small Roman 1. The provisions of clause B and so of rule 1 of rule 27, so all those relating to royalty, etc., will apply.
Yes. The important part which you want to stress is, of course, the fact that the minerals in that case vest in a person other than the government.
That's right. So it can't be taxed. It will be very, to say the least, inconsistent to the constitutional scheme that the state is paying a tax for. And the other thing is, it is the central government which is making the rules, and central government is conscious of the framework of the MMDR Act. And please see sub-rule 4, Roman 4, 45, Roman 4. If the lessee makes any default in payment of royalty as required by Section 9 or commits a breach of any of the conditions of the lease, the lessor shall give notice to the lessee requiring him to pay the. So the person will give a notice to the state government to or remedy the breach as the case may be within 60 days of the date of receipt of the notice. And if the royalty is not paid or the breach is not remedied within such period, the lessor, without prejudice to any proceeding that may take against the lessee, determine the lease. Then please see chapter 6. Now there it envisages some land where some leased area where partly it is owned by them and partly by the private person. Grant of prospecting licenses and mining leases in respect of land in which minerals vest partly in the government and partly in private persons. In Rule 53, there is chapter 3 and 4 to apply to prospecting licenses and mining leases in respect of minerals which vest partly in government and partly in private persons. The provisions of chapter 3 and 4 shall apply in relation to grant of prospecting licenses and mining leases in respect of minerals which vest partly in the government and partly in private person, as they apply in relation to the grant of prospecting license and mining leases in respect of minerals which vest exclusively in the government. At par, provided that the dead rent and royalty payable in respect of minerals which partly vest in the government and partly in private persons shall be shared by the government and by that person in proportion to the shares they have in the minerals. This can't be a sharing of tax between government and private person. The royalty will have to be understood in the normal sense, namely that since it's a joint ownership and both are together parting with their right under the lease, therefore it will be shared. Now, I will not read it, but Lordship may just note 64D, capital D. Inserted in the year 2009 with effect from 10th December 2009, where for different, they have prescribed formulas. Lordship may just glance through this.
For a moment.
Every mine owner, his agent, manager, employee, contractor, or sublessee shall compute the amount of royalty on minerals where such royalty is charged on ad valorem basis as follows. One, for all non-atomic and non-fuel minerals sold in the domestic market or consumed in captive plants or exported by the mine owners, other than bauxite and laterite dispatched.
Skip that. You may skip that.
Yes.
Come to page 1614. There is something, royalty is equal to sale
Price of mineral
multiplied by rate
into
of
rate of
royalty
royalty
percentage.
equal to total quantity of mineral produced or dispatched. So that's the formula prescribed for that particular mineral.
So has this royalty something to do with fixation of the price of the mineral?
No.
Has
So whatever be the price the lessee is selling in the market, that will be taken. And in certain cases, the royalty. Next proviso may be seen.
this between fixation of the price of a particular mineral with fixation of royalty?
Yes.
Anything of that sort?
Yes. It will depend upon that. The formula is casted in a manner
Exactly. Exactly.
that the price becomes a relevant factor and the prices are fixed by IBM.
And those prices should be uniform, perhaps.
Now kindly see royalty was the proviso. Provided that if for a particular mineral, the information for a state for a particular month is not published by the Indian Bureaus of Mines, the latest information available for that mineral in the state shall be referred, failing which the latest information for all India for the mineral shall be referred.
Indeed.
Then 2 also refers to the price published by sale price published by the IBM shall be used as a benchmark. The last 3 lines of 3 also for primary gold, silver, copper, nickel.
What is the next provision you want us to see?
And 64A contemplates interest 24% if there is delay in payment of royalty. The very fact that section 9 gives power to the central government to fix. The idea seems to be therefore that as far as royalty is concerned, the considerations which are charged by the various state governments should be on a broadly uniform basis. Rule 68 now repeals the 49 rules.
Right.
'72 is surface rent. Now kindly see the Form K in which the lease is granted at page 1644. Turn to part 5 of this Form K, will be at page 1648. Part 5 and 6, they talk of both rent and royalty. In part 7, the covenants of the lessee and lessees. 1. The lessee or lessees shall pay the rent, water rate, and royalties reserved by this lease at such times and in such manner provided in parts 5 and 6 of these presents, and shall also pay and discharge all taxes, rates, assessments, and imposition whatsoever, being in the nature of public demands, which shall from time to time be charged, assessed by the authority of the central and state governments upon or in respect of the premises, works of the lessees in common with other premises, and works of a like nature, except demands for land revenues. One
Actually,
other,
royalty is a payment made for any mineral removed or consumed
that's written.
by the lessee. See, that is evident from part 5, rule 1 or clause 1.
Yes,
Provided that where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him.
That's-
That's what fully section 9 as well says.
that's written.
That's why if you don't remove mineral or
Then dead
consume, then
rent.
you pay dead rent.
Dead rent. Or even where you have
Owner.
now 7.1, my lord, shows like see the structure of 7.1, part 7.
Computation of
The covenants. The lessee shall pay the rent, water rate, and royalties reserved.
Of royalties given, part 6, para 2, you may like to read that.
Right, that's what we are referring.
These minerals produced and dispatched.
That's
My lords are referring to which clause? My lords?
49. Part 6, clause 2. 1649.
Part 6.
get versus 1.
That's for keeping account of what is produced and dispatched. Ultimately, the point of time when the royalty is to be paid is when it is dispatched. It leaves the leased area. What I was pointing out to my lords in part 7, condition 1, is the structure, my lord, that rent, water rate and royalties reserved by this lease at such times in such manner in provided in part 5 and 6 of these presents, and shall also pay and discharge all taxes, rates, assessment and imposition whatsoever.
So taxes are used in
the nature of public demands.
Yes. So taxes are not, royalties are not subsumed in taxes.
No. Even section 25 uses royalty and tax both separately.
That we saw.
And one explanation I gave, my lord, about why only a recovery of tax provision is there, referring to the previous act and the rules. The other is, my lord, that subsequent to this act, the states are still competent under entry 50 list 2 to impose tax on mineral rights. So therefore, and it's the provisions say either under this act or this rule or the terms and conditions of the lease. So the lease condition expressly talks of royalty and tax also, because some state can, other states may not. So as the case may be, that's the expression concern. Now there are other acts, my lord, which also like All Bearing Areas Acquisition and Development Act 1957, where central government in certain states has acquired the land and then it has power to vest it in some central government company also. That also contemplates the payment of royalty. So it says that you will pay a sum which is equivalent to royalty payable under this act. Mines and mineral. I'm not referring to your lordships to all those acts because there are a number of acts where this is section 18A of All Bearing Areas Acquisition and Development Act 1957, page 1396 at 1404. Under section 10 of this act, the central government can acquire either the land itself or the rights in the land. Section 9, allow me to place 2 or 3 sections.
Coal Bearing Areas Act? Or?
Yes, coal bearing areas acquisition.
Where do we get it?
Page 1399, volume 4. Section 9 is declaration of acquisition, where the central government is satisfied after considering report, if any made under it, that any land or any rights in or over such land should be acquired, a declaration shall be made by it to that effect, and different declarations may be made from time to time in respect of different parcels of land or of rights in or over such land covered by the same notification under section 1 of 7, irrespective of whether one report or different reports has been made, provided that no declaration in respect, something like section 6 of the Land Acquisition Act. But the importance of this section is that it is the Parliament is visualizing the land itself and the rights in or over such land differently and separately. They are distinct rights. Even under the MMDR Act, when the lease is granted, so the right to the leased area in the form of lease by virtue of the grant of lease. But the right to extract the mineral and dispatch it is by virtue of the conditions of the lease. So either of the two can be acquired or both. Then 10 says, vesting of land or rights in central government. On the publication in the official gazette of the declaration under section 9, the land or the rights in or over the land, as the case may be, shall vest absolutely in the central government, free from all encumbrances. Where the rights under any mining lease granted or deemed to have been granted by a state government to any person are acquired, under this act, the central government shall, on and from the date of such vesting, be deemed to have become the lessee of the state government, as if the mining lease under the mineral concession rules had been granted by the state government to the central government, the period thereof being the entire period for which such a lease could have been granted by the state government under those rules. So if you acquire only, then you become a lessee of the state government. And 11, power of central government to direct vesting of land or rights in a government company. Notwithstanding anything contained in section 10, the central government may, if satisfied that a government company is willing to comply or has complied with such terms and conditions as the central government may think fit to impose, direct by order in writing that the land or the rights in or over the land, as the case may be, shall, instead of vesting in the central government under section 10 or continuing to so vest in the government company either on the date of publication of the declaration or on such other date as may be specified in the direction. Then 12 is king of possession. Now kindly see 18A. Payment to state government in lieu of royalty. Notwithstanding anything contained in this act where any land or any rights in or over land belonging to a state government, other than the rights under a mining lease granted or deemed to have been granted by the state government to any person vested in central government under section 10 or in a government company under section 11. The central government or the company, as the case may be, may pay to the state government such sum of money as would have been payable as royalty by lessee had such land or rights been under mining lease granted by the state government. So if the central government does not transfer it to the company and keeps it to itself and does mining, then it will pay a sum which is equivalent to royalty. Act, not then I'm done with this. This is for B, the Offshore Areas Mineral Development and Regulation Act 2002. Volume 4B, page 6. Kindly see section 16 at page 13. Worships have section 16. A lessee shall pay royalty to the central government in respect of any mineral removed or consumed from the area covered under this production is at the rate for the time being specified in the first schedule in respect of that mineral. Again, it is in respect of any mineral removed or consumed.
Right.
So the question now, my lord, is having seen the scheme of royalty, the fact that a private person pays royalty to the government and the government pays to the private person if the government is mining in an area where the minerals are owned by a private person. I submit that that fact alone is enough to conclude that royalty under the MMDR Act or the other cognate acts is not a tax. Because a tax, my lords, as enunciated by this court, is a sovereign imposition or in public interest to meet the needs of the government. And this has been so held by all the honorable judges unanimously, my lord, in Jindal's case. I'll show that those paragraphs. Here, on a holistic reason of the act, quite apart from the normal concept of royalty as we understand, is that royalty is being paid to the owner of the minerals, be it government or a private person. Logically, therefore, my lord, since the owner is parting with his right to extract and sell the minerals in the market in favor of a lessee or a deemed lessee under law, therefore, the lessee is required to pay a particular share. The other thing is that for good reasons, the framers of the Constitution have placed entry 54 in list 1 because minerals are of considerable importance to the whole country. And therefore, to an extent, as far as royalty is concerned, broad uniformity that's the idea of regulation. That's the entry says regulate mines and mineral development. Before independence, many state provinces were making their own rules and own royalty were being fixed in the way they wanted. So therefore, in the interest of the country, the fact that there is an uniformity envisaged as regards royalty would not mean, my lord, that it's a taxation. The fee can be uniform, the prices can be uniform. So various charges, levies, positions, they can all be uniform or differentiated. Even the parliament, while fixing royalty, as the lordships have seen in the rules, they can fix different royalty for different minerals. And parliament is also competent to fix a different rate of royalty for different states if it can classify it appropriately. That idea of classification remains with the central government, and it can do that. So whether it wants a complete uniformity or broad uniformity or differentiated rate of, up to the central government. Indeed. But that does not make it a tax. One of the assertions from the other side is that since it's a uniform imposition by the parliament under this, so therefore it's in the nature of tax. And for that, they draw sustenance from the word imposed in Article 366(28). Now, kindly see, my lords. Kindly see how India Cement dealt with this issue. Just one more thing, my lords, the lordship may note Schedule 6, the only place where kindly have, my lord, before the case, my lord, Schedule 6, the only place where Constitution uses the expression royalty is in Schedule 6. Kindly have clause 8 of Schedule 6. So this 6th schedule refers to Article 244(2) and 275(1). You see clause 8, the regional council for an autonomous region in respect of all lands within such region, and the district council for an autonomous district in respect of all lands within the district, except those which are in the areas under the authority of regional councils, if any, within the district, shall have the powers to assess and collect revenues in respect of lands in accordance with the principles for the time being followed by the government of the state in assessing lands for the purpose of land revenue in state generally. 2. The regional council for an autonomous region in respect of areas within such region and district council for an autonomous district in respect of all areas in the district except those which are under the authority of regional councils, if any, within the district shall have power to levy and collect taxes on lands and buildings. This is entry 49, list 2. And tolls on persons resident within such areas. The district council for an autonomous district shall have the power to levy and collect all or any of the following taxes within such districts, that is to say, 8. Taxes on professions, trades and callings and employments, taxes on animals, vehicles, boats, taxes on the entry of goods into the market for sale therein, and tolls on passengers and goods carried in ferries, taxes for maintenance of schools, dispensaries or roads, and taxes on entertainments and amusements. So a set of taxes in 8. A regional council or district council, as the case may be, may make regulations to provide for levy and collection of any of the taxes specified in subpara 2 and 3 of this paragraph, and every such regulation shall be submitted forthwith to the governor and until assented to by him shall have no effect. 9. Licenses or leases for the purpose of prospecting or for extraction of minerals. Such share of the royalties accruing each year from licenses or leases for the purpose of prospecting for or the extraction of minerals granted by the government of the state in respect of any area within an autonomous district, as may be agreed upon between the government of state and the district court of such district, shall be made over to that district council. Interesting that the district court is brought in. I don't know. Should be district council. Should be council. Yeah. If any dispute arises, shall be referred to the governor for the determination.
You see, these areas are autonomous areas, particularly from Assam. So there used to be district courts. So we do not know. We can't be very sure that it's a typo
That's
or.
why I was asking whether all books. I think
They are district council constituted as.
No, it is district council otherwise, because councils are there. So just cross check whether it is a typo or should be council, district councils are there, the elected bodies.
it's typographical.
District councils are elected bodies so far as those areas are
Yeah,
concerned.
council.
Council.
Council. What I'm trying to point out is not that taxing power has been separately mentioned in 8, and royalty is for the extraction of minerals is separately placed in 9. Just a minute.
Now?
Yes. Having placed, my lord, how the courts have dealt with this issue, just 4 or 5 cases, then I'll advert to 366/28. Kindly allow me, my lord, to read India Cement and Keshav Ram, my lord, in some detail, my lord, because the
Yes.
conflict is between those two.
In any case, that will also
approach of
cover
these two
what they would have
cases.
otherwise.
Yeah. Kindly come to page 1155,
Of
volume 5. From the very beginning, I'm placing the question involved in these. I'm so sorry.
just a
May I place it? I think Justice Bhuya is some problem.
Yes, no, it's fine.
The question involved in these appeals, especially petitions and writ petitions, is whether levy of cess on royalty is within the competence of the state legislature. In order to appreciate the question, it is necessary to refer to certain facts. Civil appeal so-and-so is an appeal by special leave from the judgment and order of the High Court of Madras dated 13th October 69. In writ appeal number 46467, the appellant is a public limited company incorporated under the Indian Companies Act 1913. The company at all relevant times used to manufacture cement in factory at Talayuthu in Tirunelveli district and at Sankari in Salem district of Tamil Nadu. By GO dated 19th July 63, the government of Tamil Nadu sanctioned the grant to the appellant mining lease for limestone and concur for a period of 20 years over an extent of 133.91 acres of land in the village of Gondanur, Taluk, Salem district, out of the extent of 133.91 acres comprised in the mining lease. An extent of 126 acres was patta land and only the balance of 7.7 acres government land. This lease was in accordance with mineral concession rules. 1960. So, part of the land was patta land and part was government land.
We have a little bit of connect on this side also.
That's right, that's it. I was about to say that.
And the most pleasant surprise on our side was Mr. Parasaran got up and supported the petition. This time also the union has filed an affidavit.
The rates of royalty, dead rent and surface rent were as follows. Royalty, limestone, all the rates are given. Then the appellant started mining operations. I'm reading para 2. Soon after the execution of the lease deed and has ever since been paying the royalties, dead rents and other amounts payable under the deed. Under section 115 of the Madras Panchayats Act, as amended by the Madras Act 18 of 64, the royalty, the appellant was required to pay local cess at 45 paisa per rupee. It may be mentioned that the said imposition was with retrospective effect along with the local cess surcharge under section 116. The contention of the appellant is and was at all the relevant times that cess on royalty cannot be levied. This may be marked that the issue is only whether cess on royalty. This is the common question which falls for consideration and requires determination in these appeals and petitions. To complete the narration of events, it has to be noted that the collector sent a communication on April 10, 1965, demanding cess or royalty payable under the Act on Minerals carried on during the period July 1, 1961 to December 31, 1964, and the petitioner was threatened by serious consequences in case of default of payment on receipt of that communication. Thereafter, writ petition number 1864 of 1965 was filed in High Court of Madras, where the judgment delivered by order so-and-so learned single judge of the Madras High Court Justice Kailasam dismissed the writ petition, holding that the cess levied under section 115 is a tax on land and as such falls under entry 49 state list of the 7th schedule of the Constitution and was within the competence of the state legislature. The reliance was placed by learned single judge on the decision of this court in HRS Murthy versus Collector of Chittor, another Constitution bench judgment of Honorable 5 judges. He held that cess levied under Section 15 was a tax on land, though fixed with a reference to the land revenue in regard to Section 116 of the Act. The learned single judge held that the maximum limit had been prescribed by the government by rules, and therefore there was no arbitrariness about the levy. Subsection 1 of Section 115 enjoins there shall be levied in every panchayat development block a local cess at the rate of 45 paisa on every rupee of land revenue payable to the government in respect of any land for every fasli. An explanation to the said section was added and deemed always to have been incorporated by the Tamil Nadu Panchayats Amendments and Miscellaneous Provisions Act 1964, being Tamil Nadu Act 18 of 1964, which provided as follows. Explanation. In this section and in section 116, land revenue means public revenue due on land and includes water cess payable to the government for water supplied or used for irrigation of land, royalty, lease amount, or other sum payable to the government in respect of land held directly from the government on lease or license, but does not include any other cess or the surcharge payable under Section 116, provided that land revenue remitted shall not be deemed to be land revenue payable for the purpose of this section. Subsection 2 of Section 115 provides that the local cess shall be deemed to be public revenue due on all the lands, in respect of which a person is liable to pay local cess, and all the said lands, the buildings upon the said lands and their products shall be regarded as the security for the local cess. Subsection so-and-so of Section 115 of the said Act deal with the application of the cess so collected for various purposes mentioned therein. In the controversy before us, the said provisions need not be considered. Section 116 of the Act is as follows. Every Panchayat Union Council may levy on every person liable to pay land revenue to the government in respect of any land in the Panchayat Union a local cess surcharge at such rate as may be considered suitable as an addition to the local cess levied in the Panchayat Development Block under Section 115, provided that the rate of local cess surcharge so levied shall not exceed rupees 250 paisa on every rupee of land revenue payable in respect of such land. The word shall not exceed 2 rupees 50 paisa on every rupee was substituted for the word shall be subject to such maximum as may be prescribed by Section 3 of the Tamil Nadu Panchayat Act 1970. And these words were substituted for the word shall not exceed 1 rupee and 50 paisa on every rupee of land revenue by Section 2 of the Amendment Act 1972. So that's how the matter came up. Now, what is to be noted is not that here the cess which has been imposed is with respect to land revenue, and royalty is one element. If we come back to the explanation in Section 5, the cess was para 5. The explanation, Section 115, shows that the cess was on land revenue and royalty was one element amongst others. For evaluating the total quantum with respect to which the cess will be calculated. It was not a simpliciter cess on royalty. The appellant, then paragraph 10, page 1158. The appellant is bound to pay royalty to the government according to the rates provided in the second schedule to the said Act of 1957. Clause 1 of Part 7 of the lease document provides as follows. The lessee shall pay the rent, water rates, royalties reserved by the lease at such times and manner provided in Part 5 and 6. I have placed this provision already. Then 11. As mentioned herein before, there is an obligation of the lessee to pay rent and other charges mentioned in the said clause. and all other central and state government dues except demands for land revenue. The question therefore which arises is cess on royalty a demand of land revenue or additional royalty? One can understand this question as posed, Lord, that because if conclusion is that the cess on, in as so far as royalty is there, the element of royalty goes up. Therefore, it's clashing with section 9. One can comprehend that part of it. But as I submitted that in this case, the cess was not on royalty, but cess on land revenue, and royalty was one factor. And kindly come to para 14.
12,
12 is a mention of counsel.
give us some more clarity.
All right.
Last 6 lines.
For the appellant and or petitioners, we have heard Mr. Nariman, Mr. Chitle, Mr. Salve, and for the interveners, Mr. K.D. Prasad, Mr. Chaudhary, Ms. Sita Vedalingam, have made the submissions for the state of Tamil Nadu. Mr. Krishnamurthy Iyer and Mr. V. Krishnamurthy have made the submissions. We have had the advantage of submissions made by Learned Attorney General on behalf of the Union of India. The issues are common in the writ petitions as well as appeal. The question involved in the appeals in the writ petition is about the constitutional validity of section 115(1) of the Act insofar as it sought to levy as local cess 45 naya paisa on every rupee of the land revenue payable to the government, meaning of land revenue being artificially expanded by the explanation so as to include royalty payable under the mining lease. In this connection, it may be appropriate to refer to the statement of objects and reasons for the amendments which stated inter alia as follows. Under the explanation to section 115 of the Act, land revenue means public revenue due on land and includes water cess payable to the government for water supplied or used for the irrigation of land, but does not include any other cess or surcharge payable under section 116. The explanation does not cover royalties, lease amount, or other sum payable to the government in respect of land held direct from the government on lease or license, which were included in the definition of land revenue under the Madras District Boards Act. As under the Madras District Boards Act 1920, certain Panchayat Union Councils continued to levy the cess and surcharge under the Madras Panchayat Act 1958 also. It is considered that the levy should be on the same basis as under the Madras District Boards Act 1920. It is therefore proposed to include royalty, lease amount, and other sums payable to the government in the definition of land revenue. In the explanation to the section 115 of the Act, and also to validate the levy and collection of the cess and surcharge made hitherto on the said basis. It is obvious that the said amendment was intended to bring royalty within the explanation and definition of land revenue in section 115, as well as section 116, and was effected by Gazette Notification 1964 by Act 18 of 1964. In order to appreciate the controversy, it has to be understood that in this case, royalty was payable by the appellant, which was prescribed under the lease deed, the terms whereof have been noted herein before. The royalty had been fixed under the statutory rules and protected under those rules. The royalty was fixed under the Mines and Minerals Regulation and Development Act 1957, which is Central Act, by which the control of mines and minerals had been taken over by the central government. It was an act for the regulation of mines and development of minerals under the control of Union of India. That act was to provide for the regulation of mines and development of minerals under the control of the Union of India. Section 2 of the Act declares that it is expedient in public interest that Union of India should take under its control the regulation of mines and mineral development to the extent provided in the Act. Section 9 is then quoted. Then para 15, the Act was passed by virtue of powers of Parliament under entry 54 of the 7th schedule. Since the control of the mines and development of minerals were taken over by the Parliament, the question that arises is whether the levy or the imposed by the state legislature imposed in this case can be justified or sustained either under 49, entry 49, 50 or 45 of list 2 of the 7th schedule. Courts of law are enjoined to gather the meaning of the Constitution from the language used, and although one should interpret the words of the Constitution on the same principles of interpretation as one applies to an ordinary law, but these very principles of interpretation compel one to take into account the nature and scope of the act, which requires interpretation. It has to be remembered that it is Constitution that requires interpretation. Constitution is the mechanism under which the laws are made and not merely an act which declares what the law is to be. See the observations of Justice Higgins in the Attorney General of State in New South Wales. In re CP and Barar sales of motor spirit, Chief Justice Guare of the Federal Court of India relied on the observations of Lord Wright in James versus Commonwealth and observed that a constitution must not be construed in any narrow or pedantic sense, and that construction most beneficial to the widest possible amplitude of its powers must be adopted. The learned Chief Justice emphasized that a broad and liberal spirit should inspire those whose duty it is to interpret the Constitution, but they are not free to stretch or pervert the language of the enactment in the interest of any legal or constitutional theory, or even for the purposes of supplying omissions or correcting supposed errors. A federal court will not strengthen but only derogate from its position if it seeks to do anything but declare the law. But it may rightly reflect that a constitution of our country is a living and organic thing, which of all instrument has the greatest claim to be construed, ut res majus veliet quam pereat. It is better that it should live than that it should perish. Certain rules have been evolved in this regard, and it is well settled that the various entries in the three lists are not powers but fields of legislation. The power to legislate is given by Article 246 and other articles of the Constitution. See the observations of this court in Calcutta Gas Company. The entries in the three lists of 7 scheduled to the Constitution are legislative heads or fields of legislation. These demarcate the area over which appropriate legislature can operate. It is well settled that the widest amplitude should be given to the language of these entries, but some of these entries in different lists or in the same list may overlap and sometimes may also appear to be in direct conflict with each other. Then it is the duty of the court to find out its true intent and purpose, to examine a particular legislation in its spirit and substance to determine whether it fits in one or the other of the lists. See the observations of this court in H.R. Banthia and S. Dillon. The lists are designed to define and delimit the respective areas of respective competence of the union and the states. These neither impose any implied restriction on the legislative power conferred by Article 246 of the Constitution, nor prescribe any duty to exercise the legislative power in any particular manner. Once the language of the entry should be given widest scope to find out which of the meaning is fairly capable of, because these set up machinery of the government, each general word should be held to extend to all ancillary and subsidiary matters which can fairly and reasonably be comprehended in it. In interpreting an entry, it should not be reasonable to import any limitation by comparing or contrasting that entry with any other one in the same list. It is in this background that one has to examine the present controversy. Here we are concerned with cess on royalty. One can have an idea as to what cess is from the observations of Justice Hidayatullah, as the learned Chief Justice then was, in Guruswamy and Company versus State of Mysore, where at page 571, the learned judge observed the word cess is used in Ireland and is still used in India, although the word rate has replaced it in England. It means a tax and is generally used when the levy is for some special administrative expense, which the name health cess, education cess, or road cess, etc. indicates. When levied as an increment to an existing tax, the same matters not for the validity of the cess must be judged of in the same way as the validity of the tax to which it is an increment. The said observations were made in the dissenting judgment, but there was no dissent on this aspect of the matter. Relying on the aforesaid observations, Mr. Nariman, appearing for the appellant, and the petitioner suggested that the impugned levy in this case is nothing but a tax on royalty and is therefore ultra vires of the state legislature. Mr. Krishnamurthy, appearing for the state of Tamil Nadu, submitted that the cess in question in the instant case is a levy in respect of land for every firstling. He urged that the words "a local cess at the rate of 45 paisa on every rupee of land revenue payable" qualify the words land revenue. These words are only intended, according to Mr. Krishnamurthy, to mean cess payable. It is, however, not possible to accept this submission in view of the obligation indicated by the language of the provision. Cess is not on land but on royalty, which is included in the definition of land revenue. None of the three lists of the schedule of the Constitution permits or authorizes a state to impose a tax on royalty. This levy has been sought to be justified under entry 45, list 2 of the 7th schedule. Entry 45 deals with land revenue, which is a well-known concept and has existed in India before the Constitution came into force. In N.R. Reddy, Justice Jagan Mohan Reddy, as the learned judge then was of Andhra Pradesh High Court, while sitting in division bench, observed that no Land Revenue Act existed in the composite state of Madras, nor had the Rayatwari system ever been established by legislative enactment. Learned judge at page 306 of the report observed that in earlier days, sovereigns had, in exercise of their prerogative right, claimed a share of the produce of all cultivated land, known as Raj Bhagam, or by any of the various other names, and had fixed their share or its cumulative money value from time to time according to their will and pleasure. The learned judge noted that as long as the share of the sovereign was being paid, the sovereign had no right to the possession of the lands, and the proprietorship of these land was vested in the occupier, who could not be removed because another offered more. The right of sovereign to share in the produce, as observed by the government of Madras, is not rent, which consists of all surplus produce after paying the cost of cultivation and the profits of agricultural stock, but land revenue only, which ought, if possible, to be so lightly assessed as to leave a surplus or rent to the occupier when he in fact lets the land to others or retains it in his own hands. It was noted that the amount of tax that was levied before the Mohammedan rule, amounting to 1/8, 1/16, 1/12 according to Manu, depending on the differences in the soil and the labor necessary to cultivate it, and it even went up to 1/4 in times of urgent necessity as of war and invasion. The later commentators Yajnavalkya, Apastambha, Gautam, Bodhayan, and Narad have all asserted not only the right but the extent of share. When the British came to India, they followed not only the precedent of the previous Mohammedan rulers, who also claimed enormous land revenue, with this difference that the Mohammedan rulers claimed they could never fully realize, but what the British rulers claimed they realized with vigor. It is not necessary to refer in detail how land revenue developed in India after the advent of the British rules. There was an appeal from the said decision of the High Court, and this court dismissed the appeal in state of AP versus N.R. Reddy. It is, however, clear that over a period of centuries, land revenue in India has acquired a connotative meaning of share in the produce of land, to which the king or the government is entitled to receive. It was contended on behalf of the appellants that the impugned measure, being a tax not on the share of the produce of land, but on royalty, royalty being the return received from the produce of the land. So far, there is no argument that royalty is tax versus share in the produce of land. The argument of the petitioners themselves. Revenue was payable for winning materials from the land. In the premises, it was contended that it cannot be attributable to entry 45, list 2 of the 7th schedule, being not a land revenue. It has, however, to be borne in mind that explanation to section 115(1) was added, and there was an amendment, as we have noted before. That very explanation makes a distinction between land revenue as such and royalty, which by amendment is deemed to be land revenue, It is therefore recognized by the very force of that explanation and the amendment thereto that the expression royalty in section 115(16) cannot mean land revenue, properly called or conventionally known, which is separate and distinct. It was also contended on behalf of the respondent state of Tamil Nadu, Mr. Krishnamurthy Iyer, that it could also be justified under entry 49 list 2 of 7 schedule as taxes on lands and buildings. This, however, cannot be accepted. In this connection, reference may be made to the decision of this court in Raja Jagannath Baksh Singh, where at page 229 it was indicated that the expression land in entry 49 is wide enough to include agricultural land as well as non-agricultural land. Justice Gajendra Gatkar, as the learned Chief Justice then was, observed that the cardinal rule of interpreting the words used by the Constitution in conferring legislative power was that these must receive the most liberal construction. And if they are words of wide amplitude, the construction must accord with it. If general word was used, it must be so construed so as to extend to all ancillary or subsidiary matters that can reasonably be included in it. So construed, there could be no doubt that the word land in entry 49 list 2 includes all lands, whether agricultural or non-agriculture. Hence, since the impugned act imposed tax on lands and building which was within the competence of state legislature and its validity was beyond challenge, but the court observed that there was entry 46 in list 2, which refers to tax on agricultural income. It is clear that agricultural income is not included in 49. If the state legislature purports to impose a tax on agricultural income, it would be referable to entry 49. Mr. Krishnamurthy Iyer relied on the said principle, but in the instant case, royalty being that which is payable on the extraction from the land and cess being an additional charge on royalty, cannot by the parity of the same reasoning be considered to be a tax on land. But since it was not a tax on land and there is no entry like 46, in the instant situation, like the position before this court, in the aforesaid decision enabling the state to impose tax on royalty, in the instant situation, the state was incompetent to impose a tax. There is a clear distinction between tax directly on land and tax on income arising out of the land. It is here not that Mr. Sirwai says that this was enough to strike it down because it's a tax on income. And it is state's own income which it is taxing. But this judgment does support, so far as entry 49 list 2 is concerned, that it is to be very widely construed and includes all types of land. The aforesaid decision confirmed the above position in new Manik Chowk spinning and weaving mills. This court, after referring to the several decisions, observed that entry 49 or list 2 of the 7th schedule only permitted levy of tax on land and building. It did not permit the levy of tax on machinery contents in or situated on the building, even though the machinery was there for the use of the building for a particular purpose. Rule 7.2 of the Bombay Municipal Corporation rules was also held to be accordingly ultra-virus in the said case. In SC non, this court had occasion to consider this and upheld the validity of Wealth Tax Act on the ground that it fell within entry 86 and not entry 49 of list 2. Construing the said entry, this court observed that entry 49 contemplated a levy on land as a unit, and the levy must directly be imposed on land and must bear a definite relation to it. So this is the case which drew the distinction between a composite tax under 86, list 1, and land as a unit, which means it should be only on land, not on all other assets. In Assistant Commissioner of Urban Land Tax versus Buckingham and Karnataka Company, this court reiterated the principles laid down in SC Non's case and held that entry 49 of list 2 was confined to tax that was directly on land as a unit. In second gift tax officer versus Nazareth, it was held that tax on the gift of land is not a tax imposed directly on land, but only on the particular user, namely the transfer of land by way of gift. In Union of India versus Dhillon, this court approved the principle laid down in Non as well as Nazareth. In Bhagwan Das Jain, this court made a distinction between levy on income from house property, which would be referable to entry 49 list 2. It is therefore not possible to accept Mr. Krishnamurthy's submission that the cess on royalty cannot possibly be said to be a tax or an impost on land. Mr. Nariman is right that royalty which is indirectly connected with land cannot be said to be taxed directly on land as a unit. In this connection, a reference may be made to the differentiation made to the different type of taxes for instances, one being professional tax and entertainment tax. In Western India theatres, it was held that the entertainment tax is dependent upon whether there would or would not be a show in cinema house. If there is no show, there is no tax. It cannot be a tax on profession or calling. Professional tax does not depend upon the exercise of one's profession, but only concerns itself with the right to practice. It appears that in the instant case also, no tax can be levied or is leviable under the impugned act if no mining activities are carried on. Hence, it is manifest that it is not related to land as a unit, which is the only method of valuation of land under entry 49 of list 2, but is relatable to minerals extracted. Royalty is payable on a proportion of the minerals extracted. It may be mentioned that the Act does not use dead rent as the basis on which land is to be valued. Hence, there cannot be any doubt that the impugned legislation in its fifth and substance is a tax on royalty and not on land. Now, in my humble submission, note, this is completely erroneous because your Lordship saw in 9A that dead rent or royalty in the alternative, whichever is higher. The court seems to be saying, had it been dead rent instead of royalty, it would have been all right. But since royalty has been brought there, therefore it is. And the other aspect, note, is that since it is dependent upon use, now the fact that land is being used or not used, note, can be a classification method. Because the government will not like to tax the land, not where for some good reason mining is not being done. It's not always that once the aspect of user comes in, therefore it automatically goes out of the fold of entry 49 is 2. Then kindly come to 24, page 116. On behalf of the state of Tamil Nadu Learned Council, Mr. Krishnamurthy Iyer sought to urge that it can also be sustained under entry 50 list 2. Entry 50 of list 2 of the 7th schedule deals with taxes on mineral rights, subject to limitation imposed by Parliament relating to mineral development. Entry 23 of list 2 deals with regulation of mines and mineral development subject to the provisions of list 1. With respect to regulation and development under control of the Union, and entry 54 in list 1 deals with regulation of mines and minerals under the control of the Union declared by Parliament by law to be expedient in public interest. Even though minerals are part of the state list, they are treated separately. And therefore, the principle that the specific excludes the general must be applied. See the observations of Waverley Jute Mills, where it was held that land in entry 49 cannot possibly include minerals. Please mark this sentence, my lords. It will not include minerals, not that it will not include the land itself. In this connection, learned Attorney General appearing for the Union of India submitted before us that in order to sustain the levy, the power of the state legislature has to be found within one or more of the entries of list 2 of the 7th schedule. The levy in question has to be either a tax or a fee or an impost. If it is neither a tax nor a fee, then it should be under one of the general entries under list 2. The expression land, according to its legal significance, has an indefinite extent both upwards and downwards the surface of the soil, and would include not only the face of the earth, but everything under it or over it. Now, this is in support of the states. doesn't go against. See the observations in Anant Mills. The minerals which are under the earth can, in certain circumstances, fall under the expression of land. But as tax on mineral rights is expressly covered by entry 50 list 2, if it is brought under the head taxes under entry 49 of list 2, it would render entry 50 of list 2 redundant. Learned Attorney General is right in contending that the entry should not be so construed as to make one entry redundant. It was further argued that even in pith and substance, the tax fell to entry list 50 list 2. It would be controlled by a legislation under entry 54 list 1. Now, there is only one problem with these observations, that Mr. Krishnamurthy wanted to justify the tax in the alternative under entry 50 list 2, saying therefore that it can be, cess on royalty can be understood since royalty is relatable to extracted mineral and dispatched mineral. Therefore, it is very proximate in nexus with entry 50 list 2. Now, what the court is saying, that the minerals which are under the earth can in certain circumstances fall under the expression land. So if it either falls under land or it falls as a mineral right. Either it goes under 49 list 2 or it comes within the fold of entry 50. If it comes under 50, then the state is competent subject to the limitations. On the other hand, Learned Attorney General submitted that if it be held to be a fee, then the source of power of the state legislature under entry 66, read with entry 23 list 2, here also the extent to which regulation of mines and mineral under the control of the union is declared by parliament by law to be expedient in public interest, to the extent such legislation makes provision, will denude state legislature of the power to override the provision of entry 50 list 2. Now, this again, in my humble submission, is completely erroneous. 54 will not denude, it will not enable Parliament to arrogate to itself any power of tax. In view of the parliamentary legislation under entry 54, declaration made under section 2 and provision of section 9 of the Act, the state legislation would be overridden to that extent. Completely erroneous in my respectful submission. Because it assumes that section 9 is a tax and tax pertaining to entry 50 list 2, and it is a limitation on that, and therefore denudation happens. Then they refer to Hingir Rampur and also the observations in state of Odisha versus Tulak. Our attention was drawn to the decision of the division bench judgment of the High Court of Mysore in Lakshmi Narayan Mining Company. There, speaking for the court, one of us, Justice Venkatramaya of the Mysore High Court, as the learned Chief Justice then was, observed that a combined reading of entry 23 and 50 of list 2 and entry 54 establishes that as long as the Parliament does not make any law in exercise of its power under entry 54, the powers of the state legislature in entry 23 and 50 would be exercisable by the state legislature. But once the Parliament makes a declaration by law that it is expedient in the public interest to make a regulation of mines and minerals development under the control of the Union to the extent to which such regulation and development is undertaken by the law made by Parliament, the power of the state legislature under 2023 and 50 list 2 are denuded. 23 is understandable. But entry 50, unless one finds a specific express limitation in the MMDR Act, made under entry 54, will not be either denuded or abstracted for me. Abstraction is absolutely not possible. Limitation is possible.
So this has to be read in the context of the facts of that case. There it was a license fee. A license fee was held to be royalty. But here the interpretation of that judgment is very wide.
Yes. That has led to the errors. I'm grateful. I'll place that case also before. To the similar effects of the observations of the High Court of Patna, that High Court of Patna, this para I'm not reading because Patna has been followed in the Karnataka case, and when I place that Mysore case, then in para 29, HRS Murthy is referred. And this was overruled by this 7 judges judgment. So let me place this extracted part of HRS Murthy. When a question arises as to the precise head of legislative power under which a taxing statute has been passed, the subject for inquiry is what in truth and substance is the nature of the tax. No doubt, in a sense, but in a very remote sense, it has a relationship to the mining as also to the mineral one from the mine under a contract by which royalty is payable on the quantity of mineral extracted. But that does not stamp it as a tax on either the extraction of the mineral or on mineral right. It is unnecessary for the purpose of this case to examine the question as to what exactly is the tax on mineral rights, seeing that such a tax is not leviable by Parliament, but only by the state, and the sole limitation on the state's power to levy the tax is that it must not interfere with a law made by Parliament as regards mineral development. Our attention was not invited to the provisions of any such law created by Parliament. In the context of Section 78, 79, and the scheme of those provisions, it is clear that the land cess is in truth a tax on land within entry 49. So HRS Murthy did not see Section 9 as a tax or a limitation on entry 50. It seems, therefore, that the attention of the court was not invited to the provisions of the Mines and Mineral Development and Regulation Act and Section 9 thereof. Section 9(3) of the Act in terms states that royalties payable under the second schedule of the Act shall not be enhanced more than once during the period of 4 years. It is therefore a clear bar on the state legislature taxing royalties so as to, in effect, amend second schedule of the Central Act. In the provision, it cannot be right to say that tax on royalty can be a tax on land. And even if it is a tax, if it falls within entry 50, will be ultra vires the state's legislative power in view of Section 9(3). In Hinger Rampur versus State of Odisha, Justice Vanchu in his dissenting judgment has stated that a tax on mineral rights being different from duty of excise pertains only to a tax that is leviable for the grant of right to extract minerals and is not a tax on minerals as well. On that basis, a tax on royalty would not be a tax on mineral rights and would therefore, in any event, be outside the competence of the state legislature. The Rajasthan, Punjab, Gujarat, and Odisha High Courts have held that royalty is not a tax. These so-and-so, so-and-so, so-and-so. It was contended. Now there is no discussion of these judgments at all, Manoj. As to what they have held, what is their logic, and what is the fallacy in those judgments. In fact, in Dr. S.S. Sharma's case, which I'll be placing, the validity of Section 9 had been questioned. That this is a tax and it's a usurpation of the power under 50. So the court said it's not a tax and therefore there's no question of usurpation. That's how it was said. In 32, it was contended by Mr. Krishnamurthy that the state has a right to tax minerals. It was further contended that if a tax is levied, it will not be irrational to correlate it to the value of the property and to make some kind of annual value basis of tax without intending to tax the income. In view of the provisions of the Act as noted herein before, this submission cannot be accepted. Krishnamurthy also further sought to urge that entry 50, there is no limitation to the taxing power of the state in view of the principles mentioned herein before and express provision of Section 9(2) or MMRD Act. This submission cannot be accepted. The field is fully covered by the central legislation. In any event, royalty is directly relatable only to minerals extracted. and on the principle that the general provision is excluded by the special one, royalty would be relatable to entry 23 and 50 list 2 and not entry 49 list 2. But as the fee is covered by the central,
The field, I think, but as the field is covered.
fee is covered by the central power,
Field.
FEE, fee.
FIELD. The typo.
Yes.
That is a typo.
Where is the typo?
Here it is a typo.
That also is.
As the field is
But
covered
as
by
the field is covered by the central power under entry 23 of or entry 50 of list 2, the impugned legislation cannot be upheld. Our attention was drawn to a judgment of the High Court of Madhya Pradesh, Hiralal Rameshwar Prasad, which was delivered by division bench, Justice J.S. Verma, acting Chief Justice, as the Lordship then was, held that the development cessed by so-and-so is ultra-virus. It is not necessary to, in the view taken by us further.
Yes, oh my God.
So just pausing, my lord, up till para 33, there is no discussion, no debate, no issue raised by any side that royalty is a tax or not. Just the Mysore High Court judgment is referred and then the 4 High Courts holding otherwise is referred. Neither of them are discussed. Because if there are 2 sets of reasoning, my lord, it would be expected, my lord, if a bench of 7 judges to discuss and debate, my lord, which one is the right one. And why Mysore should be adopted instead of the other 4. In fact, the 7 judges bench has avoided the question which of them is right. My learned friend is not quite right in saying that while getting up the judge said, my lord, and obviously that is not on record, my lord, that it is this or it is that. At least I was not there, my lord, so I will go by the record. Now kindly see, my lord, the abrupt conclusion.
Most crucial paragraph.
34.
34 is the most.
In the aforesaid view of the matter, we are of the opinion that royalty is tax. As such, cess on royalty being a tax on royalty is beyond. One can understand cess on royalty being a tax on royalty is beyond the competence. One can understand that part. But there was no issue. Issue was whether cess on royalty is good or bad. And the court is saying in the aforesaid view of the matter. So there is no view of the aforesaid matter in the previous paragraphs. Not a single sentence, not a whisper. And that's why Kesharam said, my lord, that if you say just this word is missing, in the aforesaid view of the matter, we are of the opinion that cess on royalty is a tax. That's how, my lord, this clarified this apparent error. There was no issue. No issue has been framed in any paragraph that whether royalty is a tax or not. There is no debate, no consideration of the general concept of royalty.
Read it like that. See, it's so obvious in the aforesaid view of the matter. we are of the opinion that royalty is a tax. Now we'll just leave that aside because those are the disputed words. Now see what follows.
As such,
As
cess
such
on royalty.
a cess on royalty being a tax on royalty. So the next phrase makes it
That's
very
right.
clear that what they were saying is
That was the issue.
a cess on royalty is a tax
Is a
on
tax.
royalty.
That's all that which Kesharam has tried to make it straight, consistent. And this sentence, well, the first part of the sentence has been picked up in a number of cases down the line and they all went astray.
Sentence clarified.
Now see the second and third sentence. In any event, we are
On royalty. So they tried to repeat what they had said earlier in the second part of the same sentence. In order to draw the conclusion is beyond the competence of the state.
in any event, we are of the opinion that cess on royalty, they come back to cess on royalty, cannot be sustained under entry 49 list 2 as being tax on land. Royalty on mineral rights is not a tax on land, but a payment for the user of land. This is what we are saying, that the last sentence is supporting, which I had been submitting since morning, that royalty is for not merely user. I would say even this is not fully correct, because the royalty is for transfer of the owner's right to extract the mineral and sell it. So the mineral value has to be shared by the owner and the lessee. One is the lesser is the dominant owner and the lessee is the subservient owner, having an interest in land because of the lease. So therefore, it's logical that the mineral value which is state is owning must be shared with the only the sharing mode is prescribed by Section 9. So I am not standing up to defend a cess on royalty simpliciter. Though in this case, it was a cess on land revenue by virtue of explanation, royalty was one additional factor. Even otherwise, with utmost deference to the learned judge, I submit that even if royalty, there was a problem, then that word could be struck down, though not the whole section which said cess on land revenue, including water charges and so on and so on. Especially
Orissa, for example, is straight on. That's all right.
we'll come to Odisha, don't worry. Right now I'm in Jharkhand. In this case, the cess was not on royalty directly, but a cess on land revenue. Normally, it's something like surcharge. It takes the same character.
In this paragraph 34,
Yes,
it's somewhat abruptly
that's right.
because we are not able to sort of connect with the previous paragraphs,
Yes.
the logic or the reasoning. Anyway, I'm sure.
It's an abrupt conclusion without any issue being there, without any contention being there, and without any debate or consideration of the concept of royalty as it exists. One may arrive at a conclusion that in other matters, royalty may be a consideration or a return to the owner, but in the context of mining, it is not so. But there is no debate, no consideration of that at all.
Like Justice Oja says, whether royalty is a tax or not is not very material for the purpose of determination of this question.
That side, further paragraph.
Out about the conclusion that the court
But
reached.
Justice Oza's judgment goes further down the street roads. I mean, if we accept Justice Oza, then every tax has got some land. Every business has got land. Every business is based on capital. Every business is based on labor. So this formula that a tax is on land plus capital plus labor, and this is every tax which is being imposed on capital assets or whatever, the sale tax and so on, the excise duty on manufacture. So no manufacturing can happen unless there is a capital, unless there is labor, and the factory is standing on some land based on raw material.
Cess,
But what is
on cess, there is a dissenting opinion of Justice Vanchu in Hinge Rampur.
Inge Rampur?
He says if you just because you make a fund for certain infrastructure development and you call it a cess, it doesn't mean that it is different from royalty.
That's
That
right.
is what he said.
I'll place Inge Rampur also. Lordship is right.
Excise duty.
Oh, yes, on manufacturer, extraction of
Yes.
minerals as manufacture, entry 86. 84 list 1.
Excise duty.
Problem is in the next sentence where he says, if you levy it with reference to royalty, royalty is levied with reference to production, it's an excise duty. Majority says that's a measure given by that subject. He says no, this is an excise duty. Then he says royalty is a tax on mineral rights, but royalty is also charged with reference to production. That is why India Cements at one place says very with one choose. Then royalty is also not a tax. It will be excise duty. If anything is collected on the basis of actual production, it becomes manufacture according to Justice Vanchu's logic.
So we are yet not.
That is why, my lord, we are best 9 of your lordships hear these without being.
Yes.
So just see para 40. Yes, of Justice Oza's judgment concurring. Whether royalty is a tax or not is not very material for the purpose of the determination of this question. In this case, it is admitted that royalty is charged on the basis of per unit of minerals extracted. It is no doubt true that mineral is extracted from the land and is available, but it could only be extracted if there are three things: land, capital, labor. It is therefore clear that unit of charge of royalty is not the land, but land, labor, capital. It is therefore clear that if royalty is a tax or an imposition or a levy, it is not on land alone, but it is a levy or a tax on mineral, labor, capital employed in extraction of the mineral. So even if we take this sentence as it is, my lord, it will be both land and mineral. So both entry 49 and entry 50 will be attracted. It therefore is clear that royalty, if is imposed by Parliament, it would only be a tax not only on land but on these three things stated above. Now this is based on if royalty. Royalty, if it is imposed by Parliament, as a tax. It is not in dispute that the cess which the Madras Village Panchayat proposes to levy is nothing but an additional tax, and originally it was levied only on land revenue. Apparently, land revenue would fall within the scope of entry 49. This is erroneous. It will be entry 45, land revenue. But it could not be doubted that royalty, which is a levy or tax on the extracted mineral, is not a tax or a levy on land alone, and if cess is charged on the royalty, it would not be said to be a levy or tax on land, and therefore it could not be upheld as imposed in exercise of jurisdiction under entry 49. Thus, it is clear that by introducing this explanation to section, widening the meaning of the word land revenue for the purpose of section 115 and 16, when the legislature included royalty, it went beyond its jurisdiction under entry 49 list 2 and therefore clearly is without the authority of law. But this also may lead to an interesting situation. This cess levied under so-and-so was intended to be levied on all lands falling within the area. But as this cess on royalty is without the authority, the result will be that the cess is levied so far as lands other than lands are situated are concerned. But lands where mines are situated, this levy of cess is not in accordance with that law. This anomaly could have been averted if the legislature in this explanation had used the word surface rent in place of royalty. Even if the lands where mines were situated and which are subject to license and mining leases, even for those lands, there is a charge on the basis of surface of the land, which is sometimes described as surface rent or sometimes also dead rent. Although the two are different concepts, dead rent and surface rent. It could not be doubted that if such a surface rent or dead rent is charged or an imposition on the land only and therefore will clearly fall within the purview of 49 list 2 and if excess is levied on that, it will also be justified as tax on land. So had it been surface rent and dead rent, then it is justified on 49, but not all.
What next, Mr. Vedi?
Now there are two cases in between, Milord. One is Visa Cement. Same volume, page 1329.
Oh, it doesn't.
Now, paragraph 3 suggests this is also a case of cess on royalty. Para 8, the lordships refer to the dissenting judgment of Justice Vanchu in Hinge Rampur. That's referred to in para 8. kindly come to page 1350, where the section under challenge is quoted, section 5 and then section 7. The bottom of the page 1350, the rate per year at which such cess shall be levied. If I may read the top, my lord, the rate of cess. Roman 2, the rate of cess assessment and fixation of cess here are dealt with by section 5, which reads, the cess shall be assessed on the annual value of all lands on whatever tenure held calculated in the manner hereinafter appearing. The rate per year at which cess shall be levied will be 25% of the annual value of the land. Now at page 1351 towards the bottom, section 7 defines annual value. The annual value of lands held by rayats shall be the rent payable by such rayat to the landlord. 2. In the case of lands held as an estate, the annual value shall be the aggregate of the amount which the intermediary is entitled to receive on account of revenue or rent, less the amount payable by an intermediary as revenue to the intermediary immediately superior to him or to the government, as the case may be. B. The rent, if any, payable under the land or in the khas possession. 3. In the case of lands held for carrying on mining operations, the annual value shall be royalty or, as the case may be, the dead rent payable by the person carrying on mining operations, the government. Then section 9B, in between placetum D, 7.3 is there. In the case of lands held for carrying on mining operations, annual value shall be the land, as the case may be, the dead rent payable by the person carrying on mining operations to the government, or the pit mouth value wherever it has been determined. Please come to page 1370. In the previous paragraphs, there are discussions or references to India Cement. I am leaving that because I have placed the judgment. There has been considerable discussion before us as to whether royalty itself is a tax or not. The controversy before us centers around the discussion contained in para 31 to 34 of India Cement. Judgment Counsel for the assessee respondents invite attention to the opening sentence of para 34, which runs, in the aforesaid view of the matter, we are of opinion that royalty is tax, and argue that this clinches the issue. On the other hand, Shri Iyer submits that this purported conclusion does not follow from the earlier discussion and is also inconsistent with what follows. He points out that though there is reference in para 27 to the conclusion of Justice Venkat Ramaiah in a judgment of the Mysore High Court that royalty under section 9 is really a tax, and a reference in para 31 to Rajasthan, Punjab, Gujarat to the effect that royalty is not a tax, there is no discussion, criticism or approval of any of the decisions on this point, and that therefore the first sentence of para 34 is non sequitur. He submits that perhaps there is typographical error in the first sentence of para 34 and the sentence should really read thus. So here the sentence is completely suggested in a different form. He also points out that the last sentence of para 34 reads, royalty on mineral rights is not a tax on land, but a payment for the user of land. He submits, therefore, that this issue has not been decided in India Cement. He submits that before we express any opinion on this issue, we should consider the matter afresh, and places before us extracts from various lexicons and dictionaries to show that royalty is nothing more then the rent or a lease amount payable to the lessor in consideration for the grant of lease to exploit minerals. Reference may also be made to D.K. Trivedi, para 35 so and so. It is therefore neither a fee nor a tax, but merely a price paid for the use of mineral-bearing land. We do not think it is necessary for us to express an opinion either way on this controversy, for it seems to us it is immaterial for the purpose of the present case. If royalty itself were to be regarded as a tax, it can perhaps be described properly as a tax on mineral rights. And has to conform to the requirements of entry 50, which are discussed later. We are, however, here concerned with the validity of the levy of not royalty but of cess. If the cess is taken as tax, then unless it can be described as land revenue or a tax on land or a tax on mining rights, it cannot be upheld under entry 45, 49 or 50. On the contrary, if it is treated as a fee, the state's competence to levy the same has to be traced to entry 23, a proposition the effect of which will be considered later. The question whether royalty is a tax or not does not assist us much in furnishing an answer to the two questions posed in the present case and set out earlier. We shall therefore leave this question to rest here. So it's not that for the first time suddenly, but the subsequent benches also this issue, and the learned judges obviously did not deal with that issue in this.
How long now, Mr. Yes, any reassessment of the time that you're likely to take?
We'll finish tomorrow.
Sorry?
I'd like to finish tomorrow. I'll try to finish.
Maybe everyone can now make a reassessment of the time they're going to take and then give us a fresh assessment.
Yes.
Would about lunch be all right for you tomorrow, Mr.
Lunch will not be possible.
If their side finishes tomorrow, then our side can.
Day after lunchtime.
No,
Many
this week,
states-
no, this week will be too long for this side. I think now Mr. Dwivedi has covered a very large part of his.
Some part is not covered.
You were thinking tomorrow this side can conclude. At the most, maybe 1 hour day after tomorrow, and then the other side can start. We can give you time until 11:30 on 11:30 on Thursday, isn't it? So by 11:30 on Thursday, I think this side can conclude. So please ration out the time between yourselves so that by 11:30 the baton passes on to this side. Everybody between you 11:30 on Thursday. That by 11:30 we'll start with this side.